Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hello again to some of you who were with me earlier. I was so confused because I thought I set the stream for 4 o'clock, but I didn't. I set it for 4:30. So if you weren't here for the 2 o'clock show, I had what I thought was a great show with Tom Kokanowski, who is a Massachusetts attorney who represented Brian Camp in the trial that we followed last week. And we were all collectively so happy when we watched our collective adoptive son, Brian Camp, acquitted for defending his family in a home invasion case out of Hampshire County. I thought Tom was amazing. He came on the show. We had some random weird connection that we both went to the same college. We both went to Trinity College for our freshman year. We were both freshmen. We lived in the same dorm. I left Trinity and went to Boulder, but Tom stayed there, and I thought that was a great show. So I hope you guys watched it. And I wanted to just report back to you that you guys bought every single thing on the Amazon wish list for the Camp children. So thank you. They will be adding more things to their wish list. They are so gracious, and they are so blown away by your generosity and the fact that we even asked them to set up an Amazon wish list. Thank you to Team Brittany and to one other viewer who had that idea to make this Christmas for the Camp girls just a bit better than it was 2 Christmases ago when their home was invaded by a lunatic who tried to kill their dad. And he defended himself, killed the intruder, and was just acquitted of manslaughter in Hampshire County last week or this week. I don't even know what day it is anymore. Today's Friday. Yesterday was Thanksgiving. It was this week. It restored our faith in the Massachusetts justice system just a little bit. And I think Tom's a really great guy. And I'm glad that he came on the show. And I'm glad that he got to talk to you guys and he got to answer your questions. So there's that. Yes, I also have, today is Black Pink Friday. Today's Pink Friday. So we are going to put up the QR code. I also posted it on my Instagram. So I also have it publicized there. Thank you for reminding me. Whoever in chat just did that. If you are a giver, you have the ability to, and you would like to help contribute to Karen Reed's Defense Fund, there is the QR code. It's also on my Instagram story. You can find it there. It started last night at midnight. It will go to today at midnight. Any and all donations are welcome. As you know, Karen is at least $5 million in debt to her defense team for this persecution that the Commonwealth has decided to go ahead with. So there's that. I'll leave that up there for a minute or two so you guys can screenshot it, do all the things and stuff. And as you know, every dollar helps. So no spoilers, please. I have a couple of decisions on the motions for you. Motions that were heard at the hearing that we covered on Tuesday. And also hot off the press is the fiery opposition by the Commonwealth in Aidan Kearney's case, opposing the release of Michael Morrissey's private emails and phone records. So I have that for you. That's going to be a cold read because it is so hot off the press from my amazing behind the scenes paralegals that I have not even had a chance to fully read it yet. So that is new. Thank you guys for that. As things are added to the camp children's wish list, I will let you know. Those girls, when they went through this horrific tragedy of the killing of the intruder inside their home, were, I think, 2 and 4. So I want to say now they're maybe 4 and 6. And you guys are amazing and you're generous. And I thank you, as always, for being here with me. I am thankful to all of you, and I hope you had a wonderful Thanksgiving yesterday. And even if you didn't, well, you're here with me today. So it's going to turn around. It's going to turn around for you. I can promise you. Yeah, we got all the things for you. All the things. I don't even know if Aiden has seen the opposition on this motion yet. So somebody might want to tell him because, I got it. No, Brian Camp was not. Brian Camp was out on $10,000 cash bail. Thank God. If you didn't watch that trial, or you didn't hear about it on the news, there's a reason why. It was shadow banned completely. But it is crazy. He posted something, but I don't think it was this. I thought it was something else. I don't know. In any event, we're here for it. I'm here for it. We're going to read it. We're going to go through it. And Tell the Truth says we the people, are entitled to his emails if he's using it for official business purposes. Well, yeah, I agree. I can't wait to hear this fiery response from the Commonwealth. It's not a letter. I'm not reading a letter to you. It's not a letter. It's motion papers. So I don't know. But if you already heard it and you want to go watch it somewhere else, that's perfectly fine with me. Okay, here we go. There's that. Also, what had happened was the motion for Alessi to be admitted pro hoc vice was granted. Remember, we had some, we weren't sure if that was going to happen or not based on the questioning of the judge during that hearing where, first of all, like I told you, these things are always, always, always granted. If you're not licensed to practice law in any state that you wish to practice law in, you must file a pro hoc vice application, which means that you are coming into the state for the purposes of that particular case. So if you watched the hearing with me on, I think it was Tuesday, whatever day that was, I think it was Tuesday, you will recall that the defense team wanted to add Robert Alessi, New York attorney Robert Alessi, to their team. In order to do that, because he's licensed in New York and not Massachusetts, they have to go through the same procedure that they had to go through with Alan Jackson and Eliza Little, who are both licensed in California, but not in Massachusetts. It's a very usual rubber stamp procedure where you file this motion for admission pro hoc vice. You pay a fine. You pay a fee of something like $355, and then you have to be sponsored by a Massachusetts attorney in order to become admitted for the purposes of this one particular case. During the motions hearing, Judge Canoni, and true to form, started questioning David Yannetti about why he needed to have Mr. Alessi on the defense team. And Mr. Yannetti, or Misty and Eddie, as the closed captions love to call him, said, well, Your Honor, he's an amazing trial lawyer. He's one of the best trial lawyers in the country. And he has offered to join our team, and we would love to have him. And at one point, she said, but he's not really a criminal lawyer, right? And David said, well, he does handle criminal cases, Your Honor. And we had a hypothesis. I had an hypothesis with regard to this, because on Robert Alessi's firm website, they are an international law firm with offices in many countries worldwide. And in his bio, it says that part of his specialty, I believe he's an energy lawyer primarily, but part of his specialty is Section 1983 cases against the federal government for plaintiffs who have had their civil rights violated by governmental entities. So perhaps the judge was trying to get the defense team to admit that's why he was coming on. I don't know why he's coming on, but it just struck me as a little bit odd that she would question a motion such as this that is literally rubber stamped in every single case. So here she did decide on the 26th of November, today's November 29th, to allow it. She will allow it. After hearing motion is allowed, Beverly Canoni, 11/26/24. Since then, she was fishing. Yeah, I think so too, AT. I think she was fishing. Since then, it has been publicized that Robert Alessi is working pro bono. He is not charging any money to be involved in this case. Apparently, he is so invested in this case, either by just finding out about it or some other way, that he really believes in Karen's innocence and he is willing to work for free. So to all of the Twidiots out there who are saying, where's this money coming from? How's she going to afford it? All you people who are giving money to her defense firm are being bamboozled. No, you're not. No, you're not. Because Robert Alessi is working for free. So there's that. That is the first thing. Kim Robinson says, ACLU, ring, ring. Hi, Robert. Would you like to help someone with a 1983 case? Sure, I'm on it. Click. Love you, Kim. You are so funny. You guys are like the snark tank, and you bring the snark, and you're amazing. Hanky Panky's already in here talking about the case we just talked about. Brian Camp said 19 minutes is ridiculous. He protected his family. And then adds, no one brings handcuffs and knives and a knife without a reason, right? Back on Brian Camp. And then adds, please talk to Attorney John Diaz out of Massachusetts. He's invested in the right objective. I have no idea who that is. But thank you for homework. Thank you, Peggy. I don't need any more homework. I got enough homework. Keith Incognito says, thanks for the 5. And thanks, Hanky Panky, for your generous support. After Hank said Media and Vanity Fair has information that shows Karen Read's guilt, they are withholding. I bet their lawyers called the DA's office saying, go fish elsewhere. Well, we'll see, because I don't have decisions on that yet, but I have a decision on Bill Read's cell phones and Janet Read's cell phones. So give me a sec. On top, thank you for your super sticker. And Wanda, thank you for tuning in from Canada, thanking me for the 2 streams today. The last guest was a dear man and a lawyer. Yes. So awesome. Lisa, thank you for appreciating me. I appreciate you even more. All right. So there is that. That is one thing. Alessi is in. Alessi is in as part of the defense team. Now we turn to motion for Bill Read's cell phones, which we watched with interest as Hanky Panky tried to really convince the judge that for every single reason known to man, Bill Read's cell phone records were absolutely 100% evidentiary, and they were absolutely necessary to show that Karen Read called her father at 6:30 in the morning. It wasn't 1:30 in the morning. She called her mother at 1:30 or so in the morning, and that was an unanswered call. And then Hanky Panky said he wanted the records for a month prior to show that it was an unusual call pattern, that she would never call her father at that time, and that therefore somehow that meant that she was guilty. Because apparently Hank Brennan wants everyone to think that it is completely ridiculous that a 44-year-old woman would call her mother and or her father in the middle of the night, unless she was guilty and confessing. But surprisingly, the motion for Bill Read's cell phone was denied. Denied. And you'll see the handwriting here on the bottom of the original motion. This is motion number 398. This is the motion for Verizon Wireless records of Bill Read. Denied. And it says in handwriting here, despite the detailed arguments articulated in the supporting memorandum and at oral argument, the affidavit in support of the motion is insufficient on its face. What did I say? I said that will be our catchphrase of the day. Ms. Eliza Little, it is facially insufficient, is what she said. Facially insufficient. The judge adopted her language and said, the affidavit in support of the motion is insufficient on its face and fails to meet the requirements of Lampron. Eliza Little came in with the case law, came in with the amazing argument. It did not meet the Lampron prongs. In fact, he didn't even try to meet the Lampron prongs in his affidavit. And judge adds, not only did it not meet the requirements of Lampron, it did not meet the requirements of the Massachusetts Rule of Criminal Procedure 13A2. Denied. Signed by Judge Beverly Canoni today. Today, they're working today. Interesting. Back in the day, back in the olden days when I used to walk uphill to school both ways with no shoes on in the snow, they used to take the day after Thanksgiving off, but Judge Canone is apparently signing orders today. Maybe she's under Cape House. I don't know. So there's that. In addition to that is the decision on the order for Janet Reed's cell phones, because what 44-year-old woman would call her mother at 1:30 in the morning again, unless she was going to confess. Once again, denied today, 11/29/24 by Judge Canoni. Despite the detailed arguments articulated in the supporting memorandum and at oral argument, the affidavit in support of the motion is insufficient on its face and fails to meet the requirements of Lampron and the Massachusetts Rule of Criminal Procedure 13A2. XOXO, Beverly J. Canone. I was just looking at this here because, hang on. All right. This took me back a second to Julie Nagel's Venmo, in which it said for Frank and Beverly, Beverley. Beverly. Okay, yeah, but that looked like an E to me, and I was kind of like, did she misspell her own name? Because that's like weird. Shocking in many ways, but due to the stellar legal arguments of our friend, no relation to me, Eliza Little, who knows her Lampron now, because that is the case that the judge loved to quote pretrial. Well, how does that comport with Lampron, Ms. Little? I mean, look, you guys, you go out of your posse of attorneys in the Norfolk DA's office, many of whom are highly skilled, who will not touch the hot potato that is Karen Reed, and you hire Hank Brennan, and you're paying him $75K at $250 an hour, and he doesn't meet the requirements of Lampron, or at least argue them in his affidavit supporting his motion. I mean, that's just cray. It's cray, and it's kind of inexcusable. I mean, at least make a good faith effort. What is interesting to me, though, is it doesn't say denied with prejudice. I don't know if she's going to give him a chance to correct his affidavit and argue it again. It doesn't say whether it's denied with or without prejudice. So there's that. Although the clerk's note, let's look at the clerk's note from this morning or today at some point, says the endorsement on motion for records from Verizon Wireless, that is paper number 398, which is Bill Reed's records, says denied, despite the detailed arguments articulated in the supporting memorandum and at oral argument. The affidavit in support of the motion is insufficient on its face and fails to meet the requirements of Lampron. I mean, my argument would be like, look, they shouldn't get a second bite of the apple because they should have argued it the first time, because we all know Lampron from all the pretrial motions that we watched and all of the other Rule 17 motions that we watched. And even any one of you in the chat could probably argue Lampron at this point, right? Here is an article in the Boston Herald, which for many of you is behind a paywall. So let's take a look at this. And there's Karen smiling. I'll read this to you. So I'll put on my best ASMR voice. And let's listen to this article because I know many of you are probably cleaning up from yesterday's feast and can't look at your screen. This is from, I think this is from today's Boston Herald. Yeah. Let's see. It's a little fakakta. I can't read the date. What does that say? Oh, it's actually from Wednesday. Okay. So for those of you who have not seen it yet, I will read it to you. Reed blasts fishing expedition outside court. The newest member. One sec. The newest member of Karen Reed's defense team is a New York City-based attorney who typically represents businesses in environmental and financial fights and has argued before the U.S. Supreme Court. All right, go a little bit smaller. Thank you. Norfolk Superior Court Judge Beverly Canone has accepted Reed's request for Robert Alessi to be added to her defense team, which attorneys David Yannetti, Alan Jackson, and Elizabeth Little have anchored for over 2 years. Though his background has focused on significant energy, environmental, and financial services matters, per his firm DLA Piper, Alessi has also handled many criminal cases over his career. Yannetti told Canone Thursday morning, period. The font is so small. Hang on, I got to make this bigger somehow for myself. There we go. Yannetti said that he and Alessi, who has represented defendants at the appellate and trial levels, had consulted on an undisclosed criminal matter in the past. Robert Alessi is one of the top courtroom lawyers in the country. Yannetti posted on X after a hearing on a slew of motions that Canone took under advisement. He will be with us for the retrial from start to finish because he believes in Karen's innocence and has a deep sense of justice. Alessi's profile on his firm's website lists experiences that include multiple federal and state court actions arising out of one of the largest bank frauds nationwide and a variety of domestic and cross-border criminal matters. Many of his trials have turned on the direct examination and cross-examination of experts, where he applies his scientific and technical background, his profile states. Jackson, a Los Angeles-based attorney who joined the Reed defense team in September 2022, touted in a statement how Alessi's experience and skill as a litigator is well known. And there is our friend, Misty and Eddie. Karen has received so many gracious offers of assistance from lawyers all over Massachusetts, Jackson wrote, and around the country who are disturbed by the corruption revealed during this prosecution, and we remain grateful for that. Reed owes more than $5 million in deferred legal fees ahead of the anticipated retrial in late January, according to a Vanity Fair article released last month. Prosecutors and the defense are requesting the second trial be delayed until April. Canone said Tuesday that she is still weighing her decision on that motion. She also took the prosecution's request for phone records from Reed's parents, William and Janet, among others, under advisement. And I just told you and read to you that those motions were denied. Shockingly. I mean, it was the right thing to deny them, but we've seen a lot of motions in this case that should have been denied or granted that weren't. So it is surprising. Reed, 44, is charged with second-degree murder, manslaughter while operating a motor vehicle under the influence and leaving the scene of a fatal accident. Her first trial ended with a hung jury in July. Prosecutors say Reed struck John O'Keefe, a 16-year Boston police officer, and her boyfriend of 2 years with her SUV following a drunken argument and left him to die in a snowstorm during the early morning of January 29th, 2022 in Canton. O'Keefe died at the age of 46. Defense attorneys counter that outside actors killed O'Keefe and conspired with state and local police to frame Reed for his murder. Special prosecutor Hank Brennan told Canone on Tuesday that if she grants access to William and Janet Reed's call, text, and data use records between December 30th, 2021 to January 30th of 2022, they will point to Reed's guilt. Actually, his original motion, if you recall, said 2002 to 2002. Brennan has said it's very likely, in quotes, that William Reed will be called as a witness. Hold on. Will be called to the stand in the second trial. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, Brennan said, the inference is strong evidence that Ms. Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. Either that, or she was really mad at her boyfriend who didn't come home, whom she felt was using her as a glorified babysitter, and called her mom to say, do you think it's okay if I leave a 14-year-old home alone? Because I really want to leave. John's making me mad. He's not responding to me. And there's going to be a blizzard. Oh, what do you think, Ma? Because some of us have that kind of relationship with our mother that we could call her any time of night for anything. Not just because we killed someone on purpose, which is what Mr. Brennan wants everyone to believe. And that, of course, that's the headline that, like, I don't know if it's Law & Crime or Court TV ran with. It was something like they put up a video and it said, Karen Reed knew she had done something terrible. Like that was their tagline. Like, really, that's the biggest takeaway that you took away from Tuesday's hearing, not the fact that Michael Marcy used his private email server to communicate with judges and try and strong arm them, and actually did strong arm them into giving Chris Albert, one of the percipient witnesses in this case, a restraining order against Aidan Kearney after Judge O'Malley had already denied it. Like, that's not your takeaway from the hearing? Okay. It's that Karen Reed knew she did something terrible because she called her mother, by the way, her mother at 1:30 a.m., not her father. You just can't make this up. The defense has called the request for the father and mother's records a fishing expedition. Reed used the phrase when she spoke to reporters outside the courthouse in Dedham after her hearing Tuesday about Brennan's request to gain information from local television stations and Boston Magazine. And we rewound this like 4 times and watched it because it was so on point, in my opinion. Karen Reed said to the reporters on her way outside of the courthouse and down those rainy steps, quote, isn't it amazing that I'll start again. Isn't it amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's malfeasance on all your parts if that were actually true. That's a fishing expedition. They don't exist. And they did. They ran with that. That was the soundbite, I guess, of the evening on the evening news. And for those other twidiots who are trying to construe this into some other meaning, I'll explain to you what Karen Reed meant by that, I imagine, is that your argument, Mr. Brennan, is that I confessed to all of these news outlets, and that's why you need to have their notes, the outtakes, the cutting room floor footage that didn't make it into your aired interview. Because I confessed to them. And somehow by you getting this information is going to reveal these mysterious miraculous confessions. And she's saying, well, if I did confess to them, don't you think that's what they would have published? Of course it is. Of course it is. You know it. I know it. We all know it. But good to Karen for pointing it out. And you could tell she probably just could not keep her mouth shut and she had to say something on her way out. And that's what she said. And she's 100% right. Let's face it. All right, let me just make sure I got everything there. Let's put this back up again. Once again, today is Pink Friday. If you would like to donate to the Kearney Defense Fund, maybe one of the mods could drop the actual Defense Fund link in the chat. That'd be amazing. Amazing. All right. Let's go back to the chat for a moment before we move on to the next cool thing that we're going to talk about. Brennan said Jackson and Yannetti could be witnesses. Was he serious or just threatening? I love your show. Thank you. He said they could be witnesses. He said they could be witnesses to statements that she made to the reporters. I think he just said that they were present during the interviews. I don't think that he meant that he would call them as witnesses at the trial because that would be rich. Try and disqualify them because now they're fact witnesses. That's a bit of a reach. I think that he meant they could be witnesses to whatever statements she made in front of those reporters because one or more of them were present during the interviews. So if somebody's misconstruing that in another way, it's interesting. He didn't make those arguments in his papers. So maybe what he said at the hearing is being misconstrued. Loudmouse Wildbird Rescue, thanks for the 10. Dude S, I absolutely love Tom and would enjoy seeing him again. Thank you. It would be amazing to see Brian Camp interview. I mean, he's our adopted cupcake child. I know. I think he needs a little time to heal from this whole process. So if and when Brian Camp would love to come on my show and have me interview him, I would love that as well. I would love that. But it's not something I would ever push or ask for because I feel like if he did come in my comments and he did comment to thank all of you for your support. That if he did want to speak and if he did want to speak to me, his attorney knows how to reach me. But thank you. That would be great. It would be great. And Reed 7, thank you for the 10. Thank me for the continued support of Karen and my family. Happy Pink Friday. Thank you. Thank you very much. I'm not sure. And Reed, if I know who you are, but oh, it's Nathan. I think it's Nathan. Hi, Nathan. Of course, as always. Happy Pink Friday to everyone. I can't see because the picture is so small, but I think that's you in the picture, right? It's great to see you. And it's just me screaming into a closet about truth and justice. So you don't have to thank me. It's just no thanks necessary, but thank you for the 10. Ellen Victoria Olson, thank you for tuning in. And says, if anyone overseas are having problems with donating to the Defense Fund because it's a U.S. website, I suggest PayPal for Karen as an alternative. It's worked for me. I'd rather someone else post the correct PayPal. I don't have it. But thank you so much for tuning in from overseas. This is a worldwide story. I mean, the entire world is watching, right? The entire world is watching. Let us know where in the world you're watching from if you so choose. Thank you. Angela, thanks for becoming a member. Welcome. Dave Matthews Band 22, thanks for coming in with the 5. Surprising move by Bab. Yeah, look, it's Thanksgiving. Let us give thanks and praise for every defense motion that is won at this point. So I do hope the Reed family had at least a little time to relax over the Thanksgiving holiday because here we are gearing up for trial number 2. Still don't have a decision on whether or not this trial is going to be postponed to April Fool's Day. Isn't that ironic? That's the date that Hank Brennan asked for and got the defense to consent to. But yeah, I'm surprised too. Happily surprised, but every now and then we get a win. Michelle Monaghan, thank you so much for your 5. Says your channel is awesome. In the chat, do you think Evra's making sure this time she dots every I and crosses every T? Maybe. I mean, the world is watching. Everyone knows now. The FBI is watching. Everybody's watching. I think that was the right decision under the law. Under the law, it was the right decision. You have to prove the 3 or 4 prongs of the land prawn case in order to get what you're asking for from a third party. And the fact that Brennan didn't even address it in his affidavit is telling. You could construe that one of two ways. Number one, he doesn't understand Lampron. Number two, he didn't draft it, he just signed it. Neither one of those is an acceptable answer in my views. Or number three, he really didn't have a good faith argument and therefore he just glossed over it, hoping the judge wouldn't notice. I mean, I don't think any of those are good excuses, but not my case, and I didn't write it. Angel from Australia gifted 5 memberships. Thank you so much, sweetheart. You are very kind and generous. I appreciate you so much. And to those 5 randomly selected members, new members, welcome. Julie is 46 and would still call my mom in the middle of the night. She's my best friend and my go-to. # mama's girl. Thank you, Julio. I think a lot of people feel that way. Cape Cod cred coming in. I don't know. Is that you, Tom? Is that Tom under a pseudonym? It might be. Thanks for the super chat. Or maybe it's not. Maybe it's somebody else who has a similar name. Thank you. So he says, or she says, because you're cool, kind, and super classy. Thank you. I try, you know, it's not easy because there's a lot of hatred and vitriol out there. There's a lot of hatred and vitriol out there in the cesspool of Twitter, and especially even more so since the fundraiser, since the Karen Reed fundraiser for legal defense fees, in which many of the YouTube supporters showed up to support Karen. And, you know, people are making it out like we were some, like, you know, guests at a party. We were working, like we were there working. Everyone who went because this is something that we firmly believe in. We went because we wanted to spend our time there and we wanted to, you know, pay our way there and travel there. And we did this on our own. This was not like, you know, we were like honored at some sort of party. That's the way people want to make it seem. And it's just, we were proud and honored to be there and to do whatever we could to help this amazing family who's going through some very, very, this horrific nightmare that seems like it just will never end. And it's coming up on 3 years. They did not pay us to go. No, they did not pay us to go. Absolutely not. We paid our own way. We made donation. No. So thanks for your, I mean, it's a genuine question if you're asking it in a genuine way, but no, none of us were paid to be there. We paid our own way to be there. We donated merch, we donated baskets. And if by us being there, the friends and family that were there were given more of an incentive to come because for some reason they wanted to meet us or take a picture with us, it's absolutely the least I could do. Absolutely the least I could do. So yeah. Thank you. Props to all the YouTubers shining a light on this massive injustice. And we've all been brought together by this one case that we all firmly believe in. So there's that. I don't know what PayPal you have. I don't want to share it if I don't know that it's accurate. So thank you, Ellen, for being willing to do that. But I don't put up links to things that I can't verify. So I'm not sure. Thank you, RB girl, for becoming a new member. I appreciate you very, very, very much. Let us. Yeah, this many law tubers can't be wrong, right? I don't know. You know, there's just so much misinformation out there. And for me, it always has been about the injuries. It's been about the injuries from the very beginning of this case. Having handled thousands of pedestrian versus motor vehicle accidents during the course of my career, I can tell you with 100% certainty, John O'Keefe's body was not hit by a car. It just wasn't. It just wasn't. That's how easy it is for me. So there's that. All right, let us go to, there's actually one more thing that we can look at here. This was a letter submitted the 27th to the court by Mr. Brennan. And this has to do with the jurisdictional and service issues that the judge said he could supplement. So let's just take a read through this. It's kind of dry and boring, but okay. If Brian gave it yesterday, then absolutely go to Brian's channel later and you can find it. Maybe he did a community post about it. Thank you, Purple Giraffe. Thank you, thank you, thank you. Appreciate you. All right. So the judge did allow Hank Brennan to supplement. Debbie says, I think it was Karen's way of thanking the YouTubers in person. She may not get another chance to meet all of you. Should thank you every day coming in and going out trial in person outside. No, I don't think that's what it was. I don't think that's what it was. Many of us went to the trial. We've met her. This was a night for her to relax with her family and friends who live far away. They have not been able to relax in almost 3 years. We're coming up on 3 years since the murder of Officer John O'Keefe. Will be 3 years on January 29th of 2025. And this was a chance for Karen and her family and friends who have not seen each other in a very, very long time to come together and to for them to support her. So I think us choosing to go was our way of thanking all of them, because without all of them, without these 250 people there who have been supporting this family and the defense fund for the past 2 years, and not only like financially, but also emotionally, because trust me, there are many, many people that I'm sure that Karen would like to thank. You know, the people that are standing out all the time. There will be a time for that. There will be a time for that. And I'm sure that she would not want them to come and feel like they would have to donate money or pay for a ticket or whatever. So yeah, that's the thing. So I respectfully kind of disagree with you in that respect, Debbie. I think that it was our way of showing up, putting our money where our mouths are, and saying thank you to the people that are supporting her defense. You know, at least that's the way I looked at it, you know? And it wasn't, that's just the way I looked at it. And that's the way I know that other people looked at it as well. The Las Vegas cops, the Glare, Aiden Kearney, everyone who came to support the friends and family. And that's why we went. So it wasn't like that. It wasn't like that at all. It wasn't like it wasn't about us at all. At all. All right, here we go. This is the supplemental letter regarding the service of process issues that Hank Brennan had with the networks, ABC, NBC, etc. And this is dated November 27th, which, let me just go back to my calendar here, would have been the day after the hearing. Mr. Brennan wrote this letter to the court and says as follows, Dear Judge Canoni, yesterday, shortly before the hearing on the Commonwealth's Massachusetts Rule of Criminal Procedure Rule 17 motion for the production of materials from ABC and WCVB TV, ABC filed a written opposition to the motion. The court granted the Commonwealth leave to file this post-hearing response, further addressing ABC's argument that the Commonwealth must comply with the Uniform Act to secure the attendance of witnesses from without a state in criminal proceedings. ABC is a Delaware corporation with its principal office located in New York. It sought and obtained authorization to transact business in Massachusetts as a registered corporation pursuant to GL, et cetera, 156D, and the other GL requiring submission of certificate of registration. ABC's certificate of registration attached as Exhibit A. As a registered corporation, ABC must continuously maintain in the Commonwealth both a registered office and a registered agent to receive service of process. See the General Law 156 and comment to same, copy attached here too as Exhibit B. A foreign corporation that delivers the certificate required by Section 15.03 thereby agrees that it is amenable to suit in the Commonwealth. And 1507 requires that every such corporation maintain a registered office and registered agent within the Commonwealth upon whom service of process may be made. Small font is killing me. You're killing me, Smalls. You're killing me, Smalls. Just make sure this is on continue control. The Uniform Act provides a mechanism for obtaining evidence from an individual or entity that cannot be served with a summons, subpoena, or other compulsory process in Massachusetts. The mechanism is inapplicable, whereas here, service may be properly effectuated within Massachusetts. As ABC's counsel acknowledged at yesterday's hearing, none of the cases cited in ABC's opposition holds otherwise, nor has the Commonwealth found any Massachusetts legal authority suggesting that resort must nonetheless be made to General Law 233-13B in the case of a registered corporation that is subject to service of process in Massachusetts. That Section 13B does not apply to persons or entities that may be served with process in the Commonwealth is all the clearer from Section 13C of the statute, which provides that persons furnishing evidence pursuant to a summons or order obtained under 13B are immune from service of process in the Commonwealth as to any prior matters or transactions. Finally, even if the materials requested in the Rule 17 motion are being held or maintained in New York, they remain within the possession, custody, and control of an entity subject to compulsory process here in Massachusetts. The materials are presumably kept in an electronic format and can be readily transmitted to ABC's Massachusetts Council for production. In any event, ABC has not argued that collecting and producing the materials would be unduly burdensome. For these reasons and for those set forth in the Rule 17 motion, the Commonwealth requests that the motion be granted. XOXO. Hank Brennan, specially appointed district attorney. So here what they're arguing is a jurisdictional issue rather than the substantive law about whether or not the outtakes, notes of all of these reporters should be turned over. They're arguing now a jurisdictional issue about service of process, which is kind of dry, but you do have to have proper service. And I think they'll get proper service. I don't think this is really going to be an issue. And I also think that because there's no journalistic privilege in Massachusetts, I think that these motions are going to be granted. And you know what? The defense didn't oppose them anyway. It's the networks that are opposing them because journalistic privilege. Unfortunately, I just don't think that they're going to invent one in Massachusetts. Not at this point anyway, and not in this case anyway. So there's that. Let me just go back to the chat for a minute before we move on, I think, to the Kearney case at this point, because I think we covered that stuff pretty quickly. Thank you, Jack, for becoming a new member. Hold my halo. Why isn't public outrage enough to show the appearance of bias? Seems like there are a lot of citizens screaming it. Kearney must recuse herself. That's already been tried. They tried to have her recuse herself during the first trial. It didn't work. It's also kind of interesting that in Massachusetts, in some other states, this happens as well. But in Massachusetts, the judge who you're asking to recuse herself is the one who hears the motion. Forget which other trial we watched recently where, was it the Sarah Boone trial? Where she made a motion to have the judge recused. That was in Florida, and it was a different judge who heard the motion. So there's that. Judges have a lot of discretion in their rulings. The judicial immunity is a thing. And so, my friends, that's just the way it is. It's not a Massachusetts thing. It's really just a judicial discretion thing. So there's that. All right. Now, moving on to the next prong of what we're looking at here. Private emails of Michael Marcy and private text messages of Michael Marcy in both cases. So in Karen Reed's case, they didn't argue that motion on Tuesday, surprisingly. I kind of thought they were going to, but I hadn't seen a Commonwealth opposition to it. And we heard Hank Brennan during that motions hearing say I'm working with the defense. I'm looking through everything. I'm turning stuff over as I come across it. And we're working together to try and, work it out. So he didn't oppose the motion yet. And the judge hasn't ruled on it yet. Well, we also found out during that motions hearing, which apparently none of the media ran with, is that Mr. Brennan told David Yannetti prior to that hearing, Michael Morrissey had his personal iPhone, set to delete all text messages every 30 days. So there's nothing on there going back as far as they wanted it to go, which I think was August of 2023. And when Mr. Brennan was put on the spot by the judge, who said, well, are you preserving them now? He said, well, yeah, as of, like last week or something. So obviously David Yannetti was like, look, we obviously can't trust them to turn these over. We're going to need to get them directly from the source. Or we're going to need, some sort of special master to go in. I think that's what they're arguing in Aiden's case. We went over this motion. But it's interesting that they're choosing to go through these emails and start turning stuff over to the Karen Reed defense, but doesn't seem like they want to do that in the Aiden Kearney case. So let's take a look at that opposition, which is hot off the press from the 27th. But again, I don't know that anybody's gone over it yet, but here we are. We're going over it. Let's see what they have to say for themselves. And remember, this is special prosecutor. Well, it was Ken Mello. And now it is the special prosecutor known as Robert Cosgrove, I believe, right? So let's see what they have to say. This is going to be a cold read. I only got to read as far as my red pen went, which is only like here. So let's do it. I need to, I'm parched. All right. Here we go. This is in the case of the Commonwealth versus Aiden Timothy Kearney. This is the Commonwealth's opposition to defendant's motion to compel Rule 14 discovery and for issuance of a Rule 17 summons. We went over this motion, I think it was in the last stream that we did on Aiden Kearney's case, which has a different thumbnail than this. It looks different, so you have to go look for it. But I changed the title of this stream after I scheduled the stream because I was able to get a hold of these documents. So here we are. Always ready to pivot on a moment's notice. The defendant, Aiden Kearney, has moved this court to authorize a Massachusetts Rule of Criminal Procedure Rule 17 summons to Selco Partnership DBA Verizon Wireless, here and after Verizon, for any and all emails or text messages sent or received beginning on August 10th, 2023 to the present associated with the Apple iPhone and or iCloud account assigned to private subscriber Michael Marcy. B, to retain the resultant production of records under impoundment, and C, to appoint a special master, independent from, but at the expense of, the Norfolk County District Attorney, to review the content and provide to the parties all Rule 14 discoverable statements, A, between and among the subscriber and any civilian witnesses or law enforcement witnesses or alleged victims. Okay, look how overly broad that is. Not overly broad. It's broad, but in my opinion, it's not overly broad because they want all of the private communications between District Attorney Michael Morrissey and any law enforcement witnesses, Proctor, Tully, Buchanan. Because remember, in Aiden Kearney's case, he's charged with something like 17 or 19 felony witness intimidation charges for like 17 or 19 people, including Michael Proctor, Yuri Buchanan, And we know from the receipts and the Betterow letters that Tully was communicating with Ken Mello, who was the special prosecutor in Aidan Kearney's case, using their personal cell phones, with also another alleged victim, Lindsay Gattani, and also another not so confidential informant, Kate Peter. In my opinion, all this stuff is fair game. And also between Michael Morrissey and any civilian witnesses. Well, civilian witnesses like, for example, Jennifer McCabe, Matt McCabe, Colin Albert, Julie Albert, Chris Albert, because we know from the receipts that Michael Morrissey attached to his own private email to all the judges in Stoughton that there was a text message from Jennifer McCabe, to quote Nurse Kim, to someone who said, "I'm really angry that Chris didn't get it and that Turtle Boy got some documents leaked from the court." He attached a screenshot of that text message from Jennifer McCabe in his email. Then he insisted that this needs to be stopped or immediately rectified because Jennifer McCabe has lost all faith in Stoughton courts. And then through an employee of the Stoughton District Court named Michelle Littlefield under the bus and said she must have been the one who leaked the documents to Aidan Kearney, Michael Marcy said it needs to be dealt with. Shortly after, this woman was fired, and I submit to you, she's got an amazing civil case against the district attorney and Stoughton, and like for what, being a whistleblower, even if she did, maybe she didn't even do it. It's a public record. The fact that they fired her over this, I hope she's got a good civil attorney working on this. Or alleged victims. So think of all of the victims. In Lindsay Gattani's case against Aidan, where they claim that she's the victim. So any communications between Lindsay Gattani and Michael Marcy are fair game. And all of those 17 other witnesses. Jennifer McCabe, Brian Albert, Nicole Albert, anybody who was involved in that rolling rally, anybody whose houses he went by, Elizabeth Proctor, Michael Proctor. I can't even name them all. There's so many. Colin Albert, Chris Albert, Julie Albert. The list goes on and on and on. Any communications between Marcy and any of them, because they're witnesses in Aidan Kearney's case. They are victims and witnesses, both, according to the prosecution theory, right? And any ex parte statements to the judiciary concerning the defendant herein, or any other witnesses or persons connected to the defense of the above captioned cases, or the pending case in Dedham District Court involving the same complainant. That's what they're looking for. This is the Commonwealth's opposition to that. Yoked to the defendant's breathtakingly broad Rule 17 motion, accompanied by a novel, quote, reverse taint team, end quote, procedure, is a purported Rule 14 motion directed at District Attorney Morrissey personally, largely duplicative of the avalanche of discovery demands and motions. Well, wouldn't be such an avalanche if there wasn't so much stuff to uncover in this case, based upon, I don't know, Tully handing over a full cell phone extraction of the victim, Lindsay Gattani, which led them to the private text messages between Lindsay, Kate Peter, Tully, and Mello, all in the same text chain. You can't even make this up. You could script this, but nobody in Hollywood would ever produce it because they would say it's not believable. And yet here we are. Largely duplicative of the avalanche of discovery demands and motions, some meritorious, some not, previously advanced by the defense. The present motion is utterly frivolous, designed to retard the progress of the case, and unworthy of this court's consideration and time. The Commonwealth opposes the motion and asks this court to deny it. Well, Well, Mr. Cosgrove, I think Robert Cosgrove was a judge before this, right? Funny the way it is, if you think about it, that in the Karen Reed case, they're voluntarily going through Marcy's phone and emails and giving them up. But here, oh no, Robert Cosgrove was a judge before he was anointed the second special prosecutor against Aidan Kearney. And he finds this motion to be utterly frivolous, designed to retard the progress of this case, and unworthy of this court's consideration and time. I mean, them's some fighting words. Rule 17 motion and associated requests. The purported basis for the defendant's Rule 17 request, and remember, a Rule 17 request is for third-party records. Whenever you ask for third-party records in a criminal case, you have to have the court order them so they can determine whether or not it's a fishing expedition. Is what he deems an ex parte communication to the presiding judge sitting on Mr. Kearney's case, attributing negative conduct to Mr. Kearney's on private email. Characterizing this as a knowing and willful violation, the defendant suggests it begs the question whether there were equally discoverable responses from the judiciary, and if so, did Marcy cover them or delete them? Is that a footnote? Let's see. Footnote 1. The Commonwealth cannot but applaud the defendant's restraint in forbearing from asking this court to issue Rule 17 subpoenas for any and all emails and text messages sent or received by those members of the judiciary who were sent the district attorney's alleged ex parte communication, perhaps grist for a future discovery motion. Wow, this is snarky. This is snarky. So here's what happened. What happened was, in case you're new here or you're just, need a little refresher, what happened was, after Chris Albert, who is Colin Albert's dad and husband of Julie Albert, and also a town board selectman. I guess that, selectman is a term that you don't hear that often in New York, where I live. They're town board members. I don't know. He's a selectman. He's an elected official. He tried to obtain a restraining order against Aidan Kearney, aka Turtle Boy. Judge O'Malley in Stoughton District Court denied his request for a restraining order. Well, Michael Marcy didn't like that. So what had happened was he wrote an email to not only Judge O'Malley, but the chief judge of Stoughton, I think, and a bunch of other judges were copied on the email, and maybe the clerk at Stoughton. But what had happened was he wrote it from his private email account, his iCloud account. And see, what happens is, if you're a public official, your government email is subject to FOIL requests. We call them FOIL in New York. You call them FOIA, potato, Freedom of Information Law or Freedom of Information Act, and they are discoverable. Your personal email and text messages only become discoverable if you are a government employee or public official if you use your private email and your private text messages, phone as such, to communicate for public business, which clearly he did here. All the judges were copied on it. It was a very strong email, which was a little bit, threatening. Could be consequences. We need to correct this right away because Jennifer McCabe does not have any faith in the court system, and we can't have that. We can't allow it. Miraculously, after that email went to all these judges, the restraining order was just happened. It happened. It was granted. Begs the question, doesn't it, whether any of these judges responded to that email? Don't you think that's discoverable? Don't you think that's relevant evidence in the case against Aidan Kearney? It seems like basic evidence 101. Doesn't seem like a fishing expedition. Is he going to say that it was a mistake? That Michael Marcy just must have, on his private phone, because, they have separate phones, by the way. If you're a public official, you get issued a phone, right, by the office. Then you have your private phone. It's two different phones. He just happened to pick up the wrong phone and then happened to write his email from the wrong email address. May have been born at night, but not last night, as they say. So that we'll continue after the footnote here. He adds that the other obvious issue raised is whether there are other discoverable communications memorialized and hidden away on his personal devices. Well, yeah, kind of does. Kind of does. And with the, quote, begged question and the, quote, obvious issue, the defendant clearly flags that he is improperly advancing a discovery motion cloaked in the garb of a Rule 17 motion, a point that the Commonwealth shall develop at greater length below. See Commonwealth v. Seeley emphasizing that Rule 17A2 is not a discovery tool to be invoked merely for the exploration of potential evidence. Well, this isn't potential evidence. I mean, I think we know that there's evidence in there based on just this one email. Oh, and here's what he says. What happened was this. Oh, he's going to tell us now. Cosgrove is going to tell us what happened. What happened was this. A witness in the Karen Reed case, having been victimized by the defendant's online harassment, sought a civil harassment prevention order pursuant to General Law 258E in the Stoughton District Court. Okay, so that was Christopher Albert, if you're keeping up. Personnel from the Norfolk District Attorney's Office provided standard, entirely conventional assistance to the witness in preparing and filing the necessary paperwork. Present in the room when the paperwork was filed, though not playing any official role in the receipt and handling of the application, was the clerk's office personnel member later identified by District Attorney Morrissey. On information and belief, this individual was well known among her colleagues as an admirer of the defendant's propaganda efforts on behalf of Karen Reed. Oh, so what you're saying is that Michelle Littlefield is like a Turtle Boy stan? Is that what you're saying here? Wow, let's flesh that out a little bit, shall we? And then we go to footnote number 2. And notice how he couches that by saying on information and belief. Like, I really don't know, but maybe she was. Footnote number 2. See as well Exhibit A to Attorney Bettero's letter to undersigned counsel attached to the defendant's present motion. On page 2, LOL, I have some friends that work over there that are turtle riders. Okay. There's a lot of people in the town and surrounding towns that are what they call Turtle Boy fans. They call them turtle riders, I guess. Okay. In due course, the hearing went forward. As is typical for an anti-harassment proceeding, the initial application was considered ex parte, and thus Mr. Kearney was not notified and was not present. If an order is granted ex parte, it expires within days, and the responding party is summoned in for a hearing on whether the order shall be extended on a long-term basis. The judge presiding at such a hearing considers the entire matter on a de novo basis without reference to the ex parte hearing or order. In this instance, the application was denied in the initial ex parte stage, and there was then nothing before the court. Okay. So what you're saying is it was denied, and then Marcy wrote that email to the judges. Okay, that's what it seems to. That's what he seems to be saying here. After the denial and thus the termination of the case, the district attorney sent the communication appended to the defense motion to the Chief Justice of the district court and various others, including Judge O'Malley. Right, Judge O'Malley was the one who denied it. It is notable what the communication did not do. It raised no issue concerning any active case before the court. It did not complain about the outcome of the then concluded hearing or ask that Judge O'Malley reconsider the motion or that a different judge other than O'Malley hear it. Okay, hold on. I'm going to finish this paragraph and then I'm going to go back and dissect it sentence by sentence. It did not suggest that Judge O'Malley had acted improperly or so much as hint that the district attorney would encourage the applicant to appeal the denial of the order. It did not talk about any active or criminal case involving the defendant. It did not even suggest that Mr. Kearney had acted improperly, but only made the factual observation that he was the recipient of an improper leak. In short, it was not an improper ex parte communication in any accepted sense of that term. My head is going to explode right now. Can I have like all of the Twilight Zone emojis in the chat that we have here? All of them. All of them. Okay. So let me get this straight, and he may explain it in the next paragraph, but I'm not even going to go there yet. Wow. The district attorney sent that email from his private email server. We cannot lose sight of that fact. So he doesn't bring that up here. He doesn't admit that it was from his private email. To the Chief Justice of the District Court, right, and various others, including Judge O'Malley, who denied the restraining order. But his argument here is that because the restraining order was denied, it was okay for Morrissey to make this communication surreptitiously from his private email server to all of these judges because the case was not open. Am I in the Twilight Zone here? It did not complain about the outcome or suggest that he'd happened. Okay. Okay. All right. We got to pull up the email because now my head's going to explode. My head is going to explode and you can actually be the judge of that because we're just going to pull it up. Now I just got to find it and what it's attached to. Because I don't think he attached it. Of course, he's not going to attach it here and give anybody like any easy access to it. That would just be too easy for the judge to do that. So let me see if it's in Bedrow's 1017 letter. Let's see. Wow, just wow. I mean, you want to talk about like splitting hairs and like splitting the atom here. Okay. Here's the one more time for posterity's sake. This is what he's saying. After the denial and termination of the case, so after the restraining order was denied, it is only then that DA Marcy sent the email, which he doesn't say, from his private email, to the judges, the Chief Justice of the District Court, and others. But it raised no concern that any active case, no concern about any active cases. It did not complain about the outcome that the hearing restraining order was denied, or that he reconsider it, or that it go before a different judge, or that he was acted improperly, or that he was going to encourage Chris Albert to appeal. Only that it did not talk about any active criminal or civil case about Turtle Boy. It did not even suggest that anything that Mr. Kearney did was improper, but only made the factual observation that he was the recipient of an improper leak. In short, it was not an improper. So in his mind, it is not an improper ex parte communication because it had been denied and there was no case pending. Okay. Hi, Siobhan. The handcuffs and the rubber ducky emojis are for members. That's a perk of being a member. You get all the amazing emojis here. Look, Karen Retrial, we have a lot of amazing emojis here. We have a leaf blower. We have a puffy jacket. Remember the puffy jacket that Timothy Nuttall was so convinced that John O'Keefe was wearing upon his death? We have solo cups. We've got a fan. We've got what if any. We've got so many things. Wait for us. Oh, Dr. Pepper. That was from Sarah Boone. We've got wait for us. We've got we are outraged. Yeah, that's a member perk here. So that's how you get them. 100%, Stephanie said it complained. Yeah, let's take a look at that email, shall we? Because now we got to look at it. But StreamYard's not that easy, so I got to go from window to window to window to window. Here we go. Here's the email. Let's look at it again. Email from Michael Marcy dated Friday, September 29th of 2023 from his personal iCloud account. It is to Stacey Fortes, who is the Chief Justice in Stoughton. And it is to, or CC, Thomas Ambrosino, who I believe is a judge in Stoughton, Philip McHugh, maybe another judge or a clerk, Judge O'Malley, who's the one who denied the restraining order, Linda Land, who has since jumped ship. She got the duck out of there, but she was Michael Marcy's right hand at the DA's office. And the subject is Stoughton District Court issue. And now, in case any of the judges were confused, there's a big caution at the top of this email that says caution. This email originated from outside of the organization. Do not click links or open attachments unless you recognize the sender and know that its content is safe. It was not an internal email. And it says that in a big warning at the top of the email. And here's Michael Marcy's email. Dear Judge Fortes, I'm writing to express my grave concern with actions taken by an individual employed at the Stoughton District in regard to an affidavit that was shared with a blogger. Well, that's Aidan Kearney, isn't it? Aren't we now directly talking about Aidan Kearney? He's got grave concern. Can we highlight it? Shared with a blogger. That's Aidan Kearney. Writing about an ongoing second-degree murder case. Writing about it. He doesn't like that he's writing about it, though. On 9/28 of 23, which would have been the day before this email was sent on a Friday, a witness in the Commonwealth versus Reed, R-E-E-D, murder case. This is why, my friends, in court the other day, Misty and Eddie asked the judge to tell Hank Brennan when he's searching through these emails, don't just search Reed, R-E-A-D, also search Reed, R-E-E-D, because we know that Michael Marcy misspelled it in his private email. My suggestion is, and remains, also ask for R-E-I-D or even R-I-E-D, because we know many of law enforcement in this case misspelled witnesses' names and other names on purpose. And they're maybe on purpose, maybe it was a scrivener's error. We're not really sure, but there were so many of them that it just became to be not such a coincidence anymore. Is that part of the playbook? Make sure you spell some names wrong. So if anybody ever makes a search, they won't find them. I don't know. On 9/28/23, a witness in the Commonwealth v. Reed murder case filed a request for an application for harassment prevention order, which was heard before Judge O'Malley. Okay. So Christopher Albert filed that request the day before this email was sent. Judge O'Malley heard it, I guess that same day, because this is only one day later. Says the application and affidavit were processed in the civil clerk department of the Stoughton District Court and presented to the judge, which after hearing was denied. Okay. That all happened yesterday, the day before he's sending that email. So read between the lines. Judge O'Malley denied it. We were informed by the witness and others, meaning Christopher Albert and others. Guess what? Who were those others? Because now they are all also witnesses in this case. That shortly after the hearing, that Aiden Kearney, aka Turtle Boy, was provided with a copy of the entire affidavit. Is it not a public record? There is no way that he would have been aware of the proceeding without an insider working in the courthouse. The leading individual who presents as a possible leak, possible now. She got fired over this, by the way. That's my understanding. If I'm wrong, you could tell me. But my understanding is that she got fired over this. And he's just saying it's possible. Michelle Littlefield. And then here is a copy of a screenshot of the text message from Jennifer McCabe that says, I know it's late, but I'm horrified that Chris didn't get it. And I'm even more disgusted that for the second time, someone from the court leaked it right away to Turtle Boy. This is presumably from Jennifer McCabe sending a text message to someone late at night. And it must have been the night before this email was sent, because that's the day that it was denied. And she's even more disgusted that for the second time, someone from the court leaked it right away to Turtle Boy. So this is not the first time Turtle Boy, Aiden Kearney, who's an investigative journalist, was able to obtain some things that made Jennifer McCabe very, very mad and unhappy. And then there's another screenshot here that looks like it's something from Aiden Kearney's website or somewhere, because these seem to be Aiden Kearney's words that say, then because the people who work in Stoughton District Court like me more than him, they sent me this humiliating affidavit. Okay, so he's saying here that somebody in the court sent him this affidavit. He calls it an affidavit as a joke, I think, to me, so we could shame him some more. We have put in a request for the court audio, and hopefully with a little luck, we'll have it for the live show on Sunday. Going back to Marcy's email, it says the above comments from a previous witness who also received the same treatment with their application for an HPO is attached. He's saying this previous witness, Jennifer McCabe, was also denied her restraining order. Is that what he's saying there? You can correct me in the chat if I'm wrong. So it sounds to me like if you're a judge and, Michael Marcy, the district attorney, is writing to you, Michael Marcy's pretty mad that 2 restraining orders were denied against Aiden Kearney. That's what he's implying, right? Furious. One on behalf of Jennifer McCabe and one on behalf of Christopher Albert. And Jennifer McCabe is horrified about it. She's horrified. And then so he's saying full on here, this is the previous witness who didn't get the restraining order, Jennifer McCabe. And then the comments from Clarence Woods Emerson, these comments here, AKA Turtle Boy, are attached. It's clear from the postings that Stoughton District Court is directly involved in this dissemination of information affecting our murder prosecution. Well, if you're going to make that allegation, then you're going to have to say that you believe that everything that Aiden Kearney says, that Aiden Kearney 100% is telling the truth all the time. You can't use it as a shield and a sword. You can't say Aiden Kearney's a liar, and therefore we're prosecuting him because we don't believe a word that he says because he's a lying liar who lies. But then in the next breath, in your private email to all of these judges, say Aiden Kearney is telling the truth because he said that someone at Stoughton District Court likes him better than Jennifer McCabe and therefore sent me this information. So It's also public record. So he's taking Turtle Boy's word for it, and he's saying, well, it's clear from what Aiden Kearney wrote that that's where he got it from. And then he says, from the comments of one of the witnesses, Jennifer McCabe, you can see that Jennifer McCabe, I'm inserting this here. He just wrote that. He didn't say who it was. You can see that Jennifer McCabe has completely lost all confidence in the courts of the Commonwealth. I have to agree that the actions erode the trust and integrity between the courts and the public and the relationship with the district attorney's office. We are extremely concerned that the improperly disseminated court material, unsolicited to a third party, which is continuing to cause harm and damage to Jennifer McCabe in an ongoing homicide prosecution. Oh no, improperly disseminated court material, which is continuing to cause harm and damage to Christopher Albert and Jennifer McCabe, I guess it says witnesses, in an ongoing homicide prosecution must be a violation of court policies or a potential violation of law. Well, we went over this before, but he doesn't cite any court policy or any law in this email of his from his private email server. So there's that. We also understand that Aiden Kearney had also immediately requested copies of the FTR record that was made on 9/28/23. Okay. Again, public record. Again, there is no way that he would have or should have known that that hearing took place. He's got sources everywhere. He's got sources everywhere. But you're going to fire Michelle Littlefield over it. Okay. Can't wait till that lawsuit gets filed. There are a number of concerns that we have about the possibility of having to file ongoing motions or other requests for warrants before this courts. He's threatening them. We can't trust you because you have a mole. So I'm going to write you from my private email to tell you that and to threaten you. I don't know. That will affect the orderly and fair administration of justice. These actions are completely unacceptable and must be resolved immediately. I understand that you have to do an investigation and that may take time, but you also have to provide us with some evidence and assurance that you have taken action so that we can safely continue to use the clerk's office of the Stoughton District Court. We have a number of delicate matters before them on a day-to-day basis. I await your advice. So Cosgrove's argument is that because this email does not say anywhere, Judge O'Malley, I demand that you reopen this and issue the restraining order. I demand that the restraining order matter be assigned to a different judge. I demand that. Let's see what his other arguments here were. What he did not do. I demand that. Oh, because this email did not say Judge O'Malley acted improperly by denying the restraining order, that he reconsidered the order, did not imply or did not suggest that O'Malley had acted improperly. It kind of does if you read the between the lines, doesn't it? I mean, doesn't it kind of say that? It didn't say that Michael Marcy was telling telling Chris Albert to appeal the order. Well, why would he talk about that? It didn't talk about any active criminal or civil case involving the defendant, but yeah, it kind of did. It kind of did talk about Aiden Kearney in here quite a bit. And we all know, they all know that he's got pending criminal matters because he says in here that these people are witnesses. Potato, potato. All right, let's go back to this opposition. So we're only on page 4 of 11. I mean, okay. I mean, I guess if you have no argument, this is the argument to make. I mean, I'll give them props for that. Yeah, look at all the CCs, all the other judges. Yeah, no open or pending matter like the Karen Reed case he was alluding to. I think he's splitting hairs and saying no pending or open criminal matter like the and he didn't even allude to Karen Reed. He actually spelled it out, although he spelled Reed wrong. you know, you know, there's that. But he says here, it did not talk about any active criminal or civil case involving the defendant, Aiden Kearney, because this motion is in the Aiden Kearney case. It did not even suggest that Mr. Kearney had acted improperly, but only made the factual observation that he was the recipient of an improper leak. Oh, okay. So in other words, in short, it was not an improper ex parte communication in any accepted sense of that term. Okay. Rather, the obvious and entire thrust of the district attorney's communication was his concern that leaks from the court clerk's office erode the trust and integrity between the courts and the public. And his friend Jennifer McCabe. And his concern that such conduct would be repeat. Oh, I don't really know if they're friends. I mean, who was she texting so late at night? Was it Marcy himself or someone else in law enforcement? Like Lank or Proctor, one of those guys who forwarded it on to Marcy. I don't know. We're going to find out, I guess. And is concerned that such conduct would be repeated, that the Stoughton District Court might in the future handle ongoing motions or other requests for warrants that, if leaked unsolicited to a third party, would affect the orderly and fair administration of justice. Oh, I see. So what you're saying here is that Michael Marcy had every right to send this email from his private email server, which was a mistake because, in your opinion, the orderly and fair administration of justice was at stake here? Okay. This observation was simply cold truth. But even if that were not so, it was an entirely appropriate communication. Oh my God. It's days like these that I wish that Mark Betterow could be here with me, but obviously he can't because this is his case. He can't talk about it. So I am here talking about it on my own. It was simply a cold truth. Really? Was it a cold truth? Because now what you're saying here is that you believe everything that Aiden Kearney posts. Everything that Aiden Kearney says is the truth. Aiden Kearney said somebody at the Stoughton District Court gave him that document, therefore it's true. Follow me for a second here. Aiden Kearney also said people inside the house killed Officer John O'Keefe. So is that also true? Because you can't cherry pick. You can't cherry pick Aiden Kearney's statements if you believe that he's telling the truth here, but not telling the truth in all of his blogs and all of the investigative reporting that he's done on the murder of Officer John O'Keefe. So either you believe everything Turtle Boy Aiden Kearney says, or he's a liar. Because if he's out there screaming in his blogs about certain people that he says are responsible for the murder of Officer John O'Keefe, and those things turn out to be true, he hasn't slandered or libeled anybody or defamed anybody. You following my logic here? So the FBI is just, so everything that Aiden Kearney said was true. Simply the cold truth. And because Michael Morrissey is sending this email to the judges, it's just simply the cold truth. That's where he got it from. So there's that. But even if it were not so, it was an entirely appropriate communication. Was it entirely appropriate to use your personal emails to do it? To conduct government business? He goes on to say the district attorney is the elected advocate of the people and the chief law enforcement officer from the Norfolk district. The Norfolk district attorney is responsible for enforcing the rights of the public where the Commonwealth has an interest or is a party. As the chief elected law enforcement officer, Norfolk County, overseeing the criminal justice system, the district attorney has both the right and the duty to bring the attention of the appropriate judicial officer's actions by court employees contrary to law, inappropriate, and harmful to the administration of justice. Oh, okay. So he has both the right and the duty to bring to the attention of these judges any actions by court employees contrary to law. From his private email. Look the other way. Yeah. Another one, right? Look the other way motion. If anyone in the chat mods starts like mentioning these twidiots' names in the chat, please delete them. I don't even want any mention of any of these idiots here. I don't look at Twitter. I don't care about Twitter. I don't care what they're saying about me on Twitter. I'm too old to care. I just don't care. One of those morons said the other day something about, my wrinkly old ass. Go duck yourself. Okay. Okay. I'm like 20 years older than this twisted tragedies person, which quite frankly is shocking to me. If you do the side by side on those photos. So, go for it. Because they don't stop. They're like a dog with a bone. They're like dogs with bones. They don't stop. No matter how many lawsuits they have against them for defamation, they're like the Energizer trolls. They just keep going and going and going and going. And another one who's got a $500,000 judgment against her from somebody who sued her for whatever. Chiming in. So yeah, go report those tweets on Twitter. If you're on the cesspool of Twitter. I don't care. Yeah, I'm not looking for I'm not fishing for compliments here. I don't care. I don't care. I don't care about any of these. Like, if I could tell you how little I care about any of these people, it's like I couldn't care any less about these people. But when they got my name in their mouth, when they're spewing all their BS, it's only because I make too much sense and because people listen to logic and they're all friends with Jennifer McCabe. I mean, that's what this is about. You get it, right? You get it, right? No, I don't even think it was a troll that mentioned it. It was just a regular viewer who was talking about one of these people and what they were saying about me on Twitter. I don't care. If you guys are on Twitter and you want to go and report those tweets, please. They're targeting me. It's all hate. Even more so since this fundraiser, because they don't like that I make sense. They're trying to shut me up. They tried to shut me up from the second I started reporting about this case. And apparently Kim Fair told somebody to get me a message. Oh, Kim, all of your original tweets about me from going all the way back to like March and April of 2023 are all saved. They're all in a folder. And the reason you can't find them in your own damn feed is because you were screenshotting stuff and trashing me. So take a step back, Kim. I didn't say anything negative about you on my stream. I heard you give an interview to Turtle Boy in which you said that you stay home and take care of your disabled son and that he got into a program. And I'm very happy for you. I'm very happy for you. Congratulations that your son got into a program. Very happy for you. What you do is, I'm sure, very, very hard on a daily basis. And I commend you for that. Keep your name out of my mouth. Keep your name out of my mouth on Twitter, because it's not going to end well for you. And by you telling people to come and mass report my YouTube channel, for what? For what? I'm not playing that game. I'm not. So do whatever you do. And just, it's really sad, though it's really sad that on Thanksgiving, those people had, I'm not saying her particularly, some people had nothing better to do except hate on people on Thanksgiving. Like, how sad. Don't you have like family to spend your day with? Like, could you get off of Twitter for one day? I mean, if you go through some of their accounts, it's like they tweet 60 times a day on nothing but the Karen Reed case, 60 times a day about their hatred for Karen Reed. So, I mean, when you put it that way, I'm a very, very small percentage of hate tweets from them. 60 tweets a day, really? That's not even including replies. When do you have a chance to get anything else done in your life? It's just sad. It's sad. I don't care. I really don't. So if Jennifer Coffendorfer wants to jump on that train again, I've got all those saved too. Everything's in a file. Everything's in due time. Grant Smith Ellis, all of his stuff is out there too. It's all in a file. Threatening me, thought I was somebody named Haley, thought I was releasing documents about Lindsay. It has since been discovered that Haley is really a man. It wasn't me. It's sad. It's sad. And it's not about them, because I really don't care about them. So I don't want you guys to make it about them, because it's not. But again, if you see hateful things about me on Twitter and you're on that cesspool, please, by all means, stick up for me, report the tweets. It's hateful conduct. It is inciting people. It is all the things and stuff. That's gross. Right? Imagine having nothing better to do on Thanksgiving. I know. All right, that's it. That's like more time than it even deserved. But since it was in the chat, I'm going to just squash it right here and now. All right, moving on to the ridiculous opposition. It is also, harmful to the administration of justice, according to Mr. Cosgrove. Moreover, that the leak caused witnesses in the ongoing murder prosecution to lose all confidence in the courts of the Commonwealth is certainly a fair conclusion. The defendant's immediate use of the leaked material was to publicly gloat about it and the outcome of the hearing, and to further mock the witnesses as part of his campaign of vilification against them. Mocking the witnesses, campaign of vilification. I mean, there's nothing like bringing it full circle around to prove why this argument is flawed. Because now you're connecting the two things that you said were not even connected, right? You're connecting it. As demonstrated by his post in his pseudo, not very anonymous Clarence Woods Emerson account. Quote, because the people who work in Stoughton District Court like me more than him, they sent this humiliating after David to me so we could shame him some more. We have put in a request for the court audio, and hopefully with a little luck, we'll have it for the live show on Sunday. End quote. Then he says it's all there. It's all there. The acknowledgement that a person or persons who work in the Stoughton District Court leaked the information to the defendant, the smug assertion that they did so out of bias toward the defendant, and or dislike for the applicant, the improper purpose so we could shame him some more, and the plan to further humiliate him by playing on Kearney's live YouTube show and no doubt commenting on the audio of an official court proceeding. Or I would submit it's hyperbolic. Because those of you who follow Aidan Kearney and his channel know that he can be hyperbolic and exaggeratory and over the top. And for all of the people out there who are calling him a liar, now is the one time? Now's the one time you're going to choose to call him a truth teller? That's where he got it from? And even if he didn't say that it was Michelle Littlefield. It's all there. It's all there. So now we're going to believe everything Turtle Boy says. Okay. So if Turtle Boy says the son of Julie and Chris Albert was in the house when John O'Keefe was there, is that true too? Is that true as well? Again, I'm just going to ask you to not put these people's names in my chat. I don't even want them there. Please. Trying to focus on this. So are we going to believe it or are we not going to believe it? Which one are we going to do? We're going to believe everything he has to say or not what he has to say? Hang on one sec. Nurse Kim is calling. Hang on. One moment. When Nurse Kim calls, you have to answer. Okay. There's that. He does bring the receipts. Always, Stephanie, always. But, I mean, are we going to... Yeah, of course they're going to cherry pick everything. Shield and sword, says Jadzia. Right? We all love some Nurse Kim. We do. We love Nurse Kim. Nurse Kim's the best. Hi, Suze. Aiden goes over the top and can be vulgar, but he's normally spot on. Right, but they're going to have to choose. Like, hey, Commonwealth, either he's a liar and you don't believe anything he says about what really happened in the house that night, or he's totally truthful when he says that somebody gave him this from Stoughton District Court. Like, do you see the difference? Only what they want to believe, Phoebe says. Right, exactly. And that poor woman I hope she's suing over her job. I don't know. You know what, Michelle? I've seen a lot of people have their accounts suspended lately. A lot of people. But that's just what I heard. All right. So back to the sentence that says the plan to further humiliate him by playing on Kearney's live YouTube show and no doubt commenting on the audio of an official proceeding. Differently put, the defendant took the denial of an anti-harassment order against him as both an incentive and a tool to escalate his ongoing attempted intimidation and harassment of witnesses in the pending Reed homicide case. But then it has everything to do with this case. You see, okay, I'm screaming into a closet again. Although believing the above discussion establishes that the defendant's factual predicate for obtaining a Rule 17 order is utterly devoid of merit, the Commonwealth now turns to the legal basis for a Rule 17 order. The purpose of Massachusetts Rule of Criminal Procedure 17 is to expedite the trial by providing a time and place before trial for the inspection of the subpoenaed materials. The court must balance the defendant's right to mount a defense with the Commonwealth's right to prevent unnecessary delay of the trial and unwarranted harassment of witnesses and third parties. To succeed, the moving party must establish good cause by showing 1, that the documents are evidentiary and relevant, 2, that they are not otherwise procurable reasonably in advance of trial by the exercise of due diligence. Hold on a second here. 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And 4, that the application is made in good faith and not intended as a general fishing expedition. And that's, my friends, is lamb prawn, of which we speak so often. Those are the 4 things that you have to show in lamb prawn. And because Hank Brennan did not show them in his affidavit, that they're evidentiary and relevant, that they're not otherwise procurable reasonably, because, as you know, they had Karen Reed's cell phone records, which encompassed everything that they were asking for, that they can't prepare for trial, and that it's not a fishing expedition. That's why the Rule 17 motions for the cell phone records of Mr. and Mrs. Reed were denied. Those are the lamb prawn prongs. That is what Judge Canoni said they did not meet. The issuance of a Rule 17 summons is reserved to the sound discretion of the judge. The defendant accurately outlines the legal requirements necessary for this court to order a summons and bravely asserts that he has met them. Bravely. But gives short shrift to any actual showing that he has done so. That's a tongue twister. Short shrift has done show. See? As noted, the first requirement is a showing that the documents are evidentiary and relevant. An essential. Hold on, I lost my place. Fishing expeditions are popular in Massachusetts. We absolutely do know. Deep sea fishing. They're deep sea fishing. Showing that such documents even exist. Well, I think by just showing that one email, we can assume, can we, that other emails may exist from that private email server to other judges as such, or that one of those judges would have replied to that email because somehow miraculously, tell me when the restraining order against Turtle Boy was actually granted. I don't know the dates on that. That email was on September 29th. Petty paralegal is actually a paralegal. It's like, what is shrift? What the hell are these words? Google, my friend. We always learn new words every time. Every time. The defendant has shown none of these things. Rather, the defendant argues that because he has shown that the district attorney complained about misconduct by a clerk in a concluded case. But I mean, really, how concluded was it if he did wind up getting the restraining order? And because he included a communication from a witness inferably made to someone in his office. Oh, okay. So we can infer that Jennifer McCabe made that text message to someone in Michael Marcy's office. What are your bets on who she sent it to, you guys? Because remember, the MSP investigators assigned to the district attorney's office are considered to be members, part of that office, right? Proctor, Buchanan, Lenka. But in any case, in his possession, one not hitherto, hearken, God save the Commonwealth, hitherto produced in Rule 14, that these alleged improprieties logically betoken, I mean, there's another word you don't hear a lot, betoken. Betty Paralegal's on the Google. She's going to tell us what everything means. Betoken, more of the same. No, I think we can logically make that conclusion, quite frankly. I think we can logically betoken. We can logically assume that it would betoken more of the same. I think we can. Pretty sure we can. Footnote 3 here, a little here. Says if the witness's brief expression of distress. Okay, we don't know how brief it was because we're only provided with one little snippet. So let's get the whole thing. Let's get the whole thing. If the witness's brief expression of distress at the Stoughton District Court Clerk's Office improprieties and the outcome of the proceeding is a statement within the meaning of Rule 14, it is barely so. Okay. He's like a contortionist trying to contort this argument into something credible. But okay. He urges that it is possible there's more out there. It is also possible the moon is made of green cheese. Green cheese has entered the chat, my friends. Green cheese has entered. Not only do we have B token hitherto, drift, but now we have green cheese. The moon is made of green cheese. But mere possibility, even if couched as likelihood, has never been found enough to meet the Lampron standard. C. Jones. Unable even to show that the documents he seek exist. Well, I would say I'm going to be stopping every third word if I don't shut up. All right. The defendant cannot possibly make the higher showing that they are evidentiary and relevant. Oh, yes. Oh, yes. Oh, yes. Oh, yes. So it's again. Rather, he asked this court to create at the Commonwealth's expense a special master to paw through. You know who has paws? And PAWS, I mean. Not PAUSC, but do you know who has paws? Chloe. You know who also has paws? A bunny rabbit. YYKYK. A special master to paw through over a year of the district attorney's personal cell phone documents and turn over whatever the master, in his discretion, deems discoverable. Yeah, that's how it's done. Are we supposed to trust DA Morrissey to turn over what he thinks is discoverable when he clearly might be in someone's pocket? Remember the hostage video? Ironically, the defendant quotes Lampron's stricture. Potential relevance and conclusory statements regarding relevance are insufficient. One paragraph later, he attempts to justify his motion simply by stating that the statements and discoveries sought are potentially exculpatory and reasonably expected to provide evidence. Well, that's why we have discovery rules. Brady et al. And we know that Marcy knows all about Brady because he talked about Brady so much in his letters to the Josh Levy's office about his obligations under Brady and how he has to turn over everything, whether it's exculpatory or not, whether it's evidentiary or not, just like Hank Brennan is doing in the Reed case, right? He's like, I'm turning over everything. He is not to be the arbiter of what's exculpatory and what's not, what is admissible and what is not. Just like Carrie Morrissey in New Mexico was not to be the arbiter of what was evidentiary and what was not in the Alec Baldwin case, and learned that lesson quite mightily. Apparently, Mr. Kearney does not grasp that when the Supreme Judicial Court repeatedly says that potential relevance is insufficient, as it did, for example, in Lampron, it means that potential evidence is insufficient. As the defendant failed to satisfy the first requirement of Lampron, his motion should be denied. However, the Commonwealth shall briefly address the remaining requirements, each of which the defendant has failed to meet. As the defendant correctly states, the second requirement imposes on the moving party an affirmative obligation to show that no other sources likely exist for the desired records. Consider one example of a probable applicable source. Generally, any communication by the district attorney with a court official regarding matters concerning the court's business is a public record, whether sent by private email or official email. Mr. Kearney has not shown that he has first availed himself of this option by sending a FOIL request. Okay. Although inferably he or his counsel or both are obviously acquainted with the public records law. So we're in the middle of a court proceeding during discovery, and you think that we should just make a FOIL request for this stuff when we learned just Tuesday that Michael Marcy's got his text messages and emails to delete automatically after 30 days? Okay. Footnote number 4. Exhibit C to Mr. Bettero's letter attached to the defendant's motion is a copy of the Commonwealth's contract with Special Prosecutor Ken Mello. Exhibit D is an internal email exchange to the district attorney's office between the second assistant, Margaret Krippendorf, and Deborah Leahy, a fiscal affairs officer, discussing the mechanics of preparing that contract. These documents were not provided the defendant in discovery and indeed were not sought in discovery. Rather, they were almost certainly obtained by means of a public records request. Yeah, either that or someone in the courthouse leaked them to him. I mean, that's a that's kind of a reach. Judge, don't order it. Just tell them they need to go make a FOIL request. Okay. As to the third required showing, the defendant must show that the party cannot properly prepare for trial without such production and inspection in advance of trial, and the failure to obtain such inspection may tend unreasonably to delay the trial. Apparently, he believes that an adequate showing is accomplished by reciting the magic words. Oh, there's a lot of magic words in these cases, aren't there? Similarly, he purports to satisfy the fourth requirement by stating that he's not engaged in a general fishing expedition. To the contrary, the defendant's quest is the quintessence of fishing expedition. Did anybody know that Robert Cosgrove is such a wordsmith? I mean, really, we're pulling out some major thesaurus words here. Quintessence of fishing expeditions. He adds that rather, the bias and potential bad faith of investigators and their collusion with witnesses for improper purposes is always relevant and admissible. That's funny. Here's the thing. It is up to a judge and will be up to a judge at trial to decide whether these things are admissible. Relevance is not something that is up to you, special district attorney, to decide. Right? Of course, right. But the fourth requirement is not about relevance and admissibility. Those things go to the first requirement. Moreover, the defendant's purported ex parte communication with the court and the appended comment from the witness, Jennifer McCabe, upon which he has premised his entire Rule 17 motion, do not demonstrate bias by the district attorney. And have nothing to do with any investigator in the defendant's present case. Well, we don't know that because we don't know to whom Jennifer McCabe sent that text message, right? We don't know that. And certainly do not show collusion with witnesses. Well, but the other text messages do. You see, so it's kind of hard for anybody to trust what's going on over there in that office when there's collusion, text message chains between Tully, Mello, Lindsay Gattani, and Kay Peter. Thank you, Letter Rose. Said Lauren, thank you, Letter Rose. And I'm just realizing I thought this was a different footnote, but it was part of that same other footnote that says, as of this writing, the district attorney's office has received at least one pseudonymous request for public records that would largely or completely encompass those he imagines exist in the present Rule 17 motion, as well as many other things. Well, just because someone wrote it under a pseudonym doesn't mean it's Aidan Kearney. It could be just about anyone in the public domain who heard about Morrissey's email and decided to ask for themselves. And quite frankly, how many people on Twitter use pseudonyms? Just about all of them. Just about all of them. So, there's that. Undersigned counsel does not attribute that request to the defendant, but neither does he discount the possibility. He simply does not know. You don't know what you don't know. But if you know, you know. Finally, whatever the relevance of evidence of bias, it is a vast oversimplification to say that it is always admissible. It is true that a defendant has a right to present evidence of bias. However, it has been long recognized that a defendant's right to cross-examine a witness is not absolute. As long as the judge does not bar inquiry into a relevant subject, he has broad discretion to limit the scope and extent of the inquiry. Moreover, a judge may still determine whether the weight and relevance of the proffered evidence outweighs its prejudicial effect. Yes, but that's something that is decided, by the trial judge, not you. I mean, I'm just saying. Let's all take a moment, shall we? Let's take a moment while we're thinking of it. Smash the like button because there's 4,100 here and there's only 1,700 likes. And, help a girl out with the algorithm. Or, if you're hate watching, smash the dislike button. I don't care. It's engagement. That's why so many people on Twitter are ratioed and leave all the nasty comments up. Well, maybe you can't delete them anyway, but that's why they protect their tweets and don't let anybody respond to them because they get ratioed, meaning so many more negative comments than nice ones and etc. So let's smash the like button kindly, or I'll turn off the air conditioning. Thank you. Where was I? Bias, bias, bias. As long as the judge does not completely bar inquiry into a relevant subject, he has broad discretion to limit the scope and extent of the inquiry. Moreover, a judge may still determine whether the weight and relevance of the proffered evidence outweighs its prejudicial effect. Yes, well, we'd have to see what it is before a judge can rule on that, yeah? As the defendant has failed to provide a satisfactory basis for Rule 17 summons, the court need not reach his novel proposal that the fruits of the proposed search be held by the Norfolk Superior Court Clerk's Office and then reviewed by a special master at the expense of the district attorney to go through over a year of communications on any matter whatsoever and attempt to extract the Rule 14 discoverable statements, which the defendant posits must exist. Apparently, this scheme is aimed at deflecting the oft-expressed concerns of the appellate courts, pointing out the vast amount of data often contained on cellular phones and the potential for invasion of privacy. Well, what's so interesting about that, before you go to footnote 5, is that they've been saying, the Commonwealth, that they have never had the opportunity to extract Aidan Kearney's cell phones, and they've been holding them for a year, I think, a little over a year now, and that they did not extract those cell phones because, they're waiting on a taint team. Because there may be some communications between Eden and his attorney, maybe, I think. I'm conflating my cases now, so if I am, my brain hurts too. Just tell me. But what had happened was what we discovered in the Brian Walsh case, which was, amazingly investigated, coincidentally. Brian Walsh, who is accused of dismembering and disposing of his wife Anna's body, tragically, and disposing of her body all over town in garbage bags and all kinds of different dumpsters. His phones were extracted in 24 hours and returned to him. So they do have those capabilities, in addition to the fact that it was pointed out, I think, in another motion or better letter, one of them, that the Commonwealth did indeed extract Aiden's phones within mere days, but they still have the physical devices and won't give them back. Footnote 5. The potential invasion of privacy is real. Cellular telephones are microcomputers with the capacity to function as a telephone camera, audiovisual recorder, Rolodex, calendar, library, or diary. Well, that's why they're asking for a special master. Modern cell phones have immense storage capacity. 16 gigabytes of storage accommodates millions of pages of text, thousands of photographs, or hundreds of videos. Wow, imagine what a treasure trove that could be. A cell phone may contain financial records, prescriptions, notes, and addresses. Modern application software can collect and manage detailed information about a person's life, including but not limited to medical and financial information, political and religious affiliations, addictions or substance abuse, and reproductive health. Well, thank you. Thank you for the lesson there in what smartphones contained. Appreciate it. And then goes on to say, I'm just going to leave that open for you in case you want to come back and read later because I'm losing my voice and I kind of stopped caring about how much data the cell phone includes because we know. It would also have the virtue, from the defendant's point of view at least, of delaying progress of the case towards trial by months at a conservative estimate and forcing the district attorney to financially subsidize that delay. Well, you should have thought of that before you use your private cell phone for public communication. Yeah, he forgot about evidence of corruption, right? It may be included in there too. Oh, for the ducking. Love of the Traveling Mary. Thank you to some new members, including Crash Daddy's Cannon, Amanda, and Brutally Honest 34. Appreciate you so much. And Amanda, Free Karen Reed's been here for 2 months. And Marie became a new member. Welcome. And look at Oh Sweetie, no. Oh Sweetie, yes, she did. Gifted 5 memberships. Welcome. Welcome to everyone who was gifted these memberships. And the next section is entitled Rule 14 Motion. But don't fear, we're almost done. It's only 11 pages. We're on page 10. As the defendant states, the district attorney is the chief law enforcement officer of Norfolk County, God save the Commonwealth, and the ultimate authority over all Norfolk County assistant prosecutors, whether designated assistant or special district attorneys. He is not, however, the prosecutor of the present cases. Yeah, that's right, because they had to get a special prosecutor because of their conflicts of interest. Although it is within the district attorney's power to choose and dismiss prosecutors for the present cases, and indeed to try them himself, should he so wish, he's never tried a case in Norfolk County. Just thought I'd point that out. That does not distinguish the defendant's matters from any other criminal case in Norfolk County and hardly justifies personally ordering the district attorney to dance to the tune of the defendant's discovery request. So I can't wait for that meme to come out. District Attorney Michael Morrissey personally dancing to the tune of Aidan Kearney. I'm picturing like bagpipes, maybe Pond's flute, and perhaps Michael Morrissey doing a jig. I don't know. Just came to me. Rule 14 discovery canon should be had through counsel of record, upon whom the defendant has hardly been shy in pressing his demands, whether directly or through the court. The present motion smacks less of an honest attempt. Oh, there's a missing word there. It should say to procure legitimate discovery, than one to provide fresh fodder for the defendant's various internet extravaganzas. Oh boy, it isn't an extravaganza. It is fresh fodder for Aidan Kearney's various internet extravaganzas, as if this is why he wants the information so that he can have an extravaganza about it. Okay. Let the extravaganza begin. That said, the Commonwealth recognizes its obligations under Rule 14. Oh, good. And will continue to produce the defendant any statements of persons the Commonwealth intends to call as witnesses and all exculpatory information, including any material that bears upon truthfulness or could be read as suggesting bias, as well as any material that would question one's credibility or impartiality. Oh, Commonwealth v. Lewinsky. I don't think that's Monica Lewinsky, but reminded me of her for a minute there. And there's McFarland and Graham making an appearance. If you know, you know. That includes communications made by the district attorney. Oh, okay. So you're going to look for them, but you just don't want to have a special master and have him have to turn over his emails. But in that respect, the Commonwealth has on November 26, 2024, provided the Karen Reed defense team with Rule 14 discovery, including copies of various text messages. Okay. See Appendix A. Many of these involve witnesses in the Karen Reed prosecution who, by and large, are the alleged victims and witnesses in the prosecution of Mr. Kearney. Okay. The Commonwealth is prepared to provide the same discovery in the present case, subject to the same protective orders. Conclusion. The motion should be denied. XOXO Robert Cosgrove, Special District Attorney, and Ken Mello, Special District Attorney, Assistant District Attorney, who we don't even know where Ken Mello is. Nobody has seen him. Nobody knows if he's among the living. We need proof of life on Ken Mello. I don't know where he is. They're not giving us the appendix because, you know, impoundment, which is what they call sealing in Massachusetts. And oh, boy, I cannot wait for this hearing to happen on Monday. And yes, I'll be covering that live because this will be the Aidan Kearney hearing for this and perhaps some other motions. Hang on. Just check the docket. And that'll be Monday. This Monday, 9 a.m. Oh, there's so many things happening on Monday. So many things happening on Monday. But this should be a good hearing. 9 a.m. Proof of life. You know. Have you ever watched any sort of like hostage type TV shows? Like, before we pay the ransom, we want proof of life. Send us, put her on the phone. Send us a picture with a newspaper in front of it so we know it's from today. Nathan, thank you. I thanked you earlier. Glamis, this is going back to the jurisdictional issues and the service issues, and I'm sorry I'm getting to this late, but I had to keep myself on track. Having done this for years, Hank didn't serve the foreign companies directly. They are domiciled elsewhere. They can claim journalistic privilege based on where records are physically located. I do not know the law in Massachusetts to be able to opine on that. I would need a Massachusetts attorney to opine on that. And that I do not know, but that would be a very interesting twist. If they can, if those records are stored in New York and they are, and there is some twist in the law that allows them to claim privilege in New York, that would be an interesting choice of laws question that I have not researched and I'm not able to opine about right this second, but it is very interesting. Sues, thanks for the 5. No restraining orders were granted. They changed direction and went directly to witness intimidation, felony, and picketing witnesses. So I thought after that restraining order against Christopher Albert was denied, it was then granted. Do I have the wrong information there? I thought it miraculously was granted. I thought we went over that a bunch of times, or are you referring to something else? I do not know. There was an order granted. That's what I thought. Thank you, Kristen. That's what I thought. It was granted like days later. Right. Yep. And somebody says it was not granted. And somebody says you were correct. Chris never got a restraining order, got witness intimidation charges. Whatever happened after that email was sent. So I don't want to spread misinformation. So whatever happened, there's no restraining order on Albert for the Alberts. Was there a temporary one after the one was denied? It was granted, and then when it went to Superior Court, the orders were dropped. The only person I think would be Turtle Boy to ask on this, and he's probably not here. Check my email. Okay, I'll drop what I'm doing and check my email. Okay, about what? Okay. All right, so apparently, thank you for that. Aiden tweeted earlier today. Today's the 29th. We did a public records request for all of Michael Marcy's emails sent to public officials using his burner iCloud account. They withheld embarrassing emails, he says. He used this account regularly to email dozens of judges about court business. He even mocked the trial courts and their efficiency in one email. The last email we received was the September 29th email that we know exists, in which he demanded that Judge O'Malley do more to protect witnesses like Chris Albert. They want us to believe that he just stopped using that account altogether after regularly using it since 2020. Then there are some like other pages in here. There's another like Marcy email from 2021 to another judicial person, Mary White, about the shots that people were supposed to take. So they got that, I guess. I don't know, I'm kind of confused, but thank you for sending that to me. Furious, thanks for the time. What do you make of Brennan's not objecting to essentially the same motion in the Karen Reed case versus how Cosgrove is handling it? Well, I think the more we got through that motion, the more we learned that he's willing to turn over what they turned over in the Karen Reed case, subject to a protective order. So there's that. We also have not seen any written opposition by Brennan yet. So if we do, then we'll be able to compare them. That's a great question, though, Furious, and thank you for that. Lindsay says, Marcy forced their hand in firing Littlefield because she leaked a public document. But in reality, can a public document even be leaked? Yeah, I know, right? Great question. Great question. That's why I said she has a great civil lawsuit against the county. Lindsay Tyler coming in and quoting Taylor Swift, our girl Taylor. Don't you worry your pretty little mind. People throw rocks at things that shine. I know. I repeat that often in my head. Thank you. We love Taylor Swift. I know, Scott. Scott, do not hate on my girl Taylor Swift. Thank you. Thank you so much. Melissa, thanks for hanging around with me for 3 months. Says, so much appreciation for your coverage of Karen's case. You make everything much easier to understand. Thank you. I hope I did. Today was a little bit convoluted, but I hope that I made it easier to understand. She says, free Karen Reed and Turtle Boy. Jadzia, thank you so much. Fishing expeditions are popular in Massachusetts, you know? Oh, we know. Oh, we do. Lally's timeout chair. Oh, Deanna, thanks for hanging around for 2 months. Says this keeps getting crazier and crazier. Grateful Dead quote that I always love to quote in this case. You know it's going to get stranger. So let's get on with the show. Or what's shaking on Shakedown Street? It used to be the heart of town. Tell me this town ain't got no heart. You just got to poke around. It's kind of like Shakedown Street. I mean, I feel like Dedham is like Shakedown Street. Cyber Chicken Boston, thanks for the 5. I can already hear Law Daddy typing away. So much for the long weekend, right? Because this hearing is on Monday. So somebody's furiously typing away, I would imagine. And as Friday comes, things and stuff tend to drop. Thank you. Love you back, Mandy Moo. Thank you. And also, Mary Caprio, thank you for the super sticker. Robin says, yeah, we can trust Brennan will turn over all the texts and emails. I know. That's why they want them from the third party. You heard Misty and Eddie say that. We can't. We can't trust. We need to get it from the source. We need it from Apple. We need it from Apple, especially now that we're learning that Michael Morrissey had his iPhone or iCloud or email server to delete everything automatically after 30 days. I've received different emails from different people who are techies who tell me that they are still recoverable. I've received emails from different people who have told me that that is not the default setting to do automatically delete after 30 days. And trust is a funny thing, right, Robin? I mean, once it's broken, it's really, really hard to earn back. And that applies to all things. Relationships, public officials. If you know, you know. Okay, what the duck? Yeah, when was that setting change? I want to know that too. What the duck is going on with this? The Boston Herald article about property destruction in Canton this past week. And I'm going to briefly talk about this. Apparently, last Saturday evening, a bunch of high school kids, maybe some reports say up to 100 of them, went to a house that was under construction in Canton. Many of them were on the football team of Canton High. They were stupid enough to videotape it and put it up on TikTok, Snapchat, whatever. And it was mostly boys in the video. Went into a new construction home and demolished its interior. Smashing holes in walls. There was a bunny or a rabbit. I don't know. Some kids sounded like they were saying it was a squirrel that was apparently not alive and being kicked around the house by these people. Apparently it was over like $100,000 in damage to the interior of this home. Some people are calling it a hate crime because the family is Indian, I believe. I believe the girl was, I don't know how much of this is true and how much is not true. So I don't want to spread misinformation. Maybe there were some children, kids, high schoolers involved in this who may or may not be children of people, witnesses in the Karen Reed case. And also, perhaps some of the first responders' children may have been involved. And people in the chat are putting things in there, and you can read them for yourself. I'm not going to say any of those things because I cannot confirm that they are true. What the what? Yeah. What the what? Here's what happens. And this is a hypothetical. And I have 5 kids, so I have a lot of experience with parenting and such things as that. If children grow up in an environment for which there are never any ramifications for their behavior, they grow up to just think that they can do whatever they want and there will be no ramifications for their behavior. So disturbing. Somebody said in the chat that it was like a $2 million home that was under construction. And they were stupid enough to tape record it and to put it on TikTok or Snapchat. I don't know where it is or where they posted it. But this is how stupid these kids are. And the videos are all over. So I think there's some of you in the chat who have not seen them. So let me just show you. It's disturbing because of the animal component here. Here's what I want to know. This happened on Saturday night. I think Helena Rafferty, who's the chief of Canton PD or whatever, I think she's the chief, right? Did not issue a statement until it was covered by perhaps Aiden Kearney, perhaps someone else put the videos up. How long is the police report going to be on this investigation? Because remember the Richard Schiffer investigation with regard to the little rubber ducks. And by the way, somebody posted a picture of these rubber ducks. I thought they were like the kind of rubber ducks that you put in the bathtub with you, like a rubber duck like this. Literally, the rubber ducks are like this big. There was a picture of one of the rubber ducks next to a soccer ball. They're teeny tiny. They're like literally this big. How long is the police report going to be on this investigation? The one on Richard Schiffer for the rubber ducks was something like 36, 38 pages. The investigation that they did about these rubber ducks, they did a trash pull at Richard Schiffer's house. They dug through his garbage, sent subpoenas to makestickers.com. They went to his office and stuck a USB flash drive into his telematics infotainment system of his Toyota truck on Richard Schiffer to get all of his GPS data to see if he was near where any of these ducks or these like monopoly money type $100 bills were found? Is there going to be any report into these kids? It's disturbing video. It's out there. I'm going to show it to you. Let's take a look. All right. Here we go.
Who's getting hit with the squirrel?
No, who put that shit there, bro?
Who did this?
Who did it?
Who did it?
Who did it?
I mean, I'm not digging. I'm not gonna kick any holes in the wall.
Why is it so
Throw the broom through it.
Tell me how not hard it's going to be to figure out who this kid is. Look at his shoes. He's got socks on with like flip-flops. You could see like the logo on the back of his backpack. You could see the hat that he's wearing. You could see like the tag on the back of his shirt.
TK. No. We have to. Dude, this house is never getting finished.
This house is never getting finished. You hear that? I can't play the music because they'll strike me. So let me just mute it. So suffice to say that this is set to some sort of, I don't know what, like a rap song or something. Wait. Here they are vandalizing the property. Apparently there was like 100 kids who showed up. And then some of the Twidiots, some of those same people that are, hating on everybody who are friends with the McCabe's and Alberts and whatever, are justifying this behavior. They're pinning it on the girl. They're like, well, the girl shouldn't have invited all these people over to her house. Anybody ever know of like high school parties that go on where a girl invites over like a couple of people and all of a sudden 100 people show up? That's what happened here. They're trying to pin it on the girl now. Listen. Apparently they're trying to cover up who's ever like whatever TikTok or whatever this person is by using those sticker emojis. They're so proud of it though that they're like videotape. Look at the damage to this home. Over $100,000. The home was not even finished. Why? Exactly. Why? I would love to know why. Because kids like this have never had any ramifications for their behavior. Kids like this are stupid enough to film themselves doing it and then post it on social media. And then, of course, there were other kids there too who like didn't stop it from happening. The animal thing is horrific. Well, here's more. Like, that's not enough. So let's look at, there's another video. They keep surfacing. Trust me when I tell you that if any parents who have any integrity whatsoever, have any kids that were there, they will make their kids go to law enforcement. But I mean, quite frankly, who? What law enforcement you go to? Who are you going to trust? And show them the videos that they took. And you better, start talking and start naming names because like, this is no joke. This is felony territory, my friends. Property destruction like this. I'm going to have to mute this again because it's also got a song in it. So there you go. Canton's finest. Proud of the work they did destroying that person's home. I mean, I don't know. Where are my Massachusetts attorneys in the chat? Could it be a hate crime? It's horrifying. Absolutely horrifying. And apparently there's some, like maybe the girl was there and then she left and they're blaming the girl for leaving. Like, what is she supposed to do? Who's she going to call? Like, these kids are like unruly. They're unstoppable. They're, insanity. Yep. Norfolk County will always pin it on the girl. Yep. That's what a lot of people are saying. When will this investigation be completed? Sinbad, thanks for hanging around for 4 months. What are the odds that there will be text messages from Judge Canoni? Don't know. Good Citizen, Massachusetts Brady List has Marcy, Fanning, and Mello as pending per the Massachusetts Bar Association. You know, a lot of those websites are like not accurate. They're like random websites that are, I don't know if that's really the Bar Association website, but there are websites that are made to look like other websites where sort of like Wikipedia, where anybody can go on there and just add stuff. So I don't want to spread misinformation because I can't speak to the truth of that, but I believe that you saw it somewhere. I don't know if it's, accurate. People put stuff on, websites like that, and I don't know. Jazia, thank you so much for your compliment. Finally got around to ordering some Fenty lip products. Oh, good. You're going to like them. Let me know how you like them. Thank you so much for your super chat. TK, the full report will be within 8 to 13 months for all non-participants. Likely names spelled wrong and dates wrong. Holding breath is optional, but not recommended. Do you think they're going around this property and looking for ring camera footage of these kids, coming up on the property, climbing over a fence, to make some identifications? Do you think that that is something that they would do? You think they're pulling any ring camera footage? Mean Mock, thanks for being a member for 3 months. And Queen Olive also for being a member for 6 months. For what? Why did the damages? They were drinking. You can see beers in their hands. You can see, what's going on. I don't know that it was personal against the family. I don't know. Boys will be boys, right? Locker room stuff. I don't know. Bad seeds. I don't know. It's horrific. It's horrific. And people were saying in their tweets, people who are local to Canton, the girl is not an insider. The girl who owns the house and her family, they're not insiders. They're not Canton royalty. Thank you, Leslie, for the Venmo. I appreciate you so much. She says, I rock. No, you rock. No, you rock. Pin it on the girl. You're not from here. You're not a Canton regular. And so therefore, as such, you deserve it. I don't have words either. I don't have words. I'm outraged. You don't go here. Yeah, I'm outraged. We are all outraged. We are collectively outraged. Collectively outraged. And any DUI charges coming. I don't know if they were driving. I don't know. Psychopaths. I mean, I don't know that I'd want to live there. I'd be like, you know what? Let's go. Let's get out of here. Do you know? I mean, and think about not only the family who's devastated now, but here there's an article. Somebody actually posted a link to the article that says Canton home damaged by numerous juveniles. I'll just read that to you. There's the Boston Herald article. They actually reported on it. I'm shocked. When is this dated? This is dated yesterday. Let me see if I can pull this up for you. Are any charges coming at all? This is felony property damage. $100,000 in damage? It's major. Canton home damaged by, quote, numerous juveniles. Not part of the clique. Canton Police Department is investigating extensive damage to a home in the community involving numerous juveniles. We are aware of and have been actively investigating a recent malicious damage incident involving numerous juveniles since we received the call for service late Sunday morning. Canton Police Chief Helena Rafferty said in a statement Wednesday afternoon. The incident is under active investigation, and when pressed for further information, Rafferty said that a report on the incident was not yet available. Shock and horror. Rafferty said that her department is in constant contact with the contractor and homeowner and has engaged outside municipal police agencies to assist us with the extensive interview process of those involved and other aspects of the case. Well, could it also be, and I'm just speculating here, I'm spitballing with you, brainstorming, Canton PD could be conflicted out. Is Kevin Albert still a police officer with Canton PD, or did he retire? That they could be conflicted out. But if there was a Lank involved, doesn't that also conflict out? Isn't Lank MSP? They're going to have to, where are they going to call people in from other counties? Like, what are they going to do? Yeah, how do we make this go away? How do we make this go away? What do we got to do? What do I got to do? What do I got to have in this hand over here to make you forget about what's over here? Kevin is still a police officer, as is Michael Lank. I mean, there's speculation, rumor, and innuendo. Are these kids over 18? If they're in high school, they may be. If they're seniors, they could be 18. Diane says the homeowner will have to go after the parents civilly. The police probably won't press charges or assist in any prosecution. The people of Canton are going to be up in arms if they do not press charges. In my opinion, I don't know. I know a lot of you don't even want to admit that you're from Canton, don't want to come in the chat, don't want to speak out, but think about like how outraged is the community going to be if they do not prosecute this, when they are prosecuting Richard Schiffer for rubber ducks. Okay, so they need outside municipal agencies. And then it says Canton as a community has been under turmoil on the national stage as the place where Boston police officer Don O'Keefe and resident Sandra Birchmore died under criminally contested circumstances. Well, at least they're saying that, criminally contested circumstances. The case has led to an ongoing audit of the local police department. O'Keefe's death specifically has come under the glare of the national spotlight at the center of the Karen Reed case. Prosecutors have charged Reed, 44, a resident of Mansfield, with the murder of O'Keefe, her boyfriend of about 2 years, at the time of his death on January 29th, 2022. Norfolk County prosecutors say Reed ran O'Keefe down with her Lexus SUV and left him to freeze and die on the front lawn of Canton home. Birchmore was pregnant when she died on February 1st of 2021, what appeared to be a suicide attempt in her Canton apartment. But federal prosecutors say she was impregnated by a Stoughton cop who had groomed her since she was a child and then killed her to cover up his crimes and staged the scene to look like a suicide. Oh, yes. And if you're not familiar with the Sandra Birchmore case, in that case, Trooperino, as we call him, or Trooper Nick Garino, missed or couldn't find over 36,000 text messages between Stoughton police officer Matthew Farwell and the victim, Sandra Birchmore, who he groomed from the time she was 15 and took her virginity, in Matthew Farwell's phone. And yet, those same 36,000 text messages were found in Sandra Birchmore's laptop or MacBook, which the Canton PD had from the day of the incident. So there's that. Thank you, True Crime Addict, for becoming a new member. I appreciate you so much. So there's that. We're lost in the Twilight Zone. We're lost. We are so lost. Let me see if I save. Let me see if I saved that picture that somebody sent me about, or if I could find where I put it, about the soccer ball next to the duck. Oh, here we go. Can you even see it, my friends? That's a soccer ball. I think it's a soccer ball. Is it a volleyball or soccer ball? Here's the duck. See? Here's the duck. Yeah, just when you think things can't get any worse. It's a micro duck. Joseph Kane, it is a micro duck. Hello, cupcake. Yes. Oh, so yeah, what else is happening on Monday? Thank you, Sherilyn, so much for your cash app. So very much. And Kia, thank you, who says, so no neighbors heard the 100 people that were at this party. 100 plus children vandalizing a house. I don't know where it is. I don't know if it's new construction. I don't know if it's on 10 acres of land. I don't really know anything about it. So I don't know. But yeah, again, why are they not out there searching for footage? Maybe they are. Maybe they are. I don't know. I don't know, because far be it for me to know much of anything. But in addition to on Monday, Aidan Kearney's case is also the closing arguments in the Daniel Penny trial, which will not be televised. And I just can't make it there. I got too many other things to cover. We also, Sarah Boone is being sentenced on Monday at 1:30. There's a Brian Walsh hearing on Monday. I do not know at what time that is. If we can do it all, we're going to do it all, because we're here for all of it and we're following all of these cases. So that is 1, 2, 3, 4 things right there. And then what else is the week bringing to us? Tuesday is the Ashley Benefield sentencing. I don't know how that's going to happen if there's no decision on this juror issue in the Ashley Benefield case. Also, Farwell is due in federal court on Tuesday, which will not be televised, but hopefully we will find out what's going on. I don't know. Is anybody going to be boots on the ground? Is anybody going to go to federal court at 9:30 in the morning for the Farwell hearing on Tuesday? It's been adjourned several times. So I don't know. Yeah, the other cops that had relations with Sandra should be in prison too. I agree with you. I agree with you, Amy, but here we are. Yes, that Jamie Komorowski case is very interesting to me. Is that her name? She is that may begin. So jury selection is going to start. I won't cover the jury selection, but if there's enough interest in that, she is the woman who was drunk like 3 times over the legal limit. And she did she drive her car into a golf cart carrying a bride and groom and killed them and is now on trial? And she was like 3 times the legal limit. I'm interested in that. If there are any other trials that you want to cover live, let me know, because if everyone's covering that, then, and there's something else that's interesting. Yeah. Okay, good. All right. Okay, let's do it. But I won't start it on Monday, because I don't, first of all, they sometimes don't let cameras in for jury selection. I just find that part boring. I want to start with openings, and maybe we'll go into that statement. Maybe we'll go into that trial as jurors and not do a whole lot of research on it. So let's do that. Shall we? Hi, Bob Weir. Bob Weir in the house. What happened to the other cops involved in Sandra Birchmore? Were they charged? No, nobody was. How long to put these kids in jail? I wish I knew. True Crime Act. Thank you. Also, hi, Laura. It's the same as the troublemakers in the 80s, 90s, aughts, 10s, and 20s. Still unoriginal and destructive. Will mommy and daddy protect them? 80s and 90s, we didn't have cell phones. Nobody was recording it. The fact that it's stupidity, Laura. Stupidity. I don't even, I can't even I can't wrap my brain around it. What's that, 10 a.m.? Thank you. KLM, Farwell Court, December 3rd at 10. I don't know why I have it in my calendar for 9:30, but Moakley Courthouse. Thank you, KLM, for the 5 and for 10. Look at Camille coming in with 10 memberships. 10 memberships. Congratulations to everyone. And Mama She for coming in here with a very lovely Cash App for the end of the stream. Hang on, because I think I'm gonna. I want to put up the QR code one more time for the Karen Reed Pink Friday, for anybody who would like to contribute to that. And then I think I'm going to teleport you over, to Nurse Kim, who is also doing a fundraiser for Karen Reed for another hour or so. And Mama She, I hope you had an amazing Thanksgiving as well. Thank you so much for that. Back to the chat for a moment before we No, Darlene, it was not Aiden Kearney who put those ducks around town. It is another man who's being prosecuted for that. His name is Richard Schiffer. Oh, thanks, Camille. Says you're welcome. Really need to support the channel. Thank you. I appreciate you so much. So much. And I'm thankful for each and every one of you. Sarah, thanks for the fun. My kids would never be allowed out again. All the money going to those poor people. They would be learning home repair. Sent you a Venmo Tuesday. Did I get it? I did. I always respond to them. So thank you. If it came after the stream, and if I did not send my little thank you note, I always do. So hang on. Yes, I wrote you back. Thank you, Sarah, so much. Sarah says, I can't tell you how much I appreciate you. It's so nice to watch all this with you, getting your opinions and insights, the way you're so respectful of other people's experiences, and you're also a fellow deadhead, and that's an added bonus. And I did send you 2 messages back, so if you didn't get them, maybe your Venmo notifications are not working or something. But thank you so very much. I do appreciate you ever so much. Ever so much. And Magnolia Gypsy, love you. 9 beautiful months here as a cupcake and is here for it. Let me grab that QR code one more time if I can even find it, because everything is all over the place now. You know what? I might have closed it, but let me see. You guys rewind and go back and get it, and please. And let me just see if I can set up a redirect to Nurse Kim. And then that way we can do like a cupcake invasion over there. Let's see. Hope everyone had a lovely, lovely holiday. Okay, so Nurse Kim is doing a free Karen Reed Pink Friday streamathon. I'm going to redirect you over there. So buckle up, buttercups, your seatbelts. And let's do a cupcake invasion. She says, here's what she says. She's going till 8:45. And anybody who wants to donate, she's very funny. She has Auntie Deb on there all the time. I don't know who's on there right now, but look at Jack coming in here and gifting 10 memberships. Thank you, Jack. So kind and generous of you. I appreciate you so. Into the new 10. Welcome to Cupcake Nation. Speaking TC, thanks for the 5. That list shows the corrupt judges since Marcy wasn't afraid to list them. Are you talking about the list that somebody put out before? Or the list of people he CC'd on his email? Interesting. Thanks for the 5. All right, my friends, thank you so much for being with me and hanging around with me. And there's still at least 3,500 of you here. Smash the like button on your way out. Smash the like button on the way into Nurse Kim. Also, feel free to comment, share out the stream, leave nice messages. And as such, it helps the algorithm because people need to know more about this. People need to know the Las Vegas cops are on. All right, I may jump over there too. I have the link. You may see me in a few minutes after I take a little comfort break. We're heading on over to Nurse Kim. So do all the things and stuff and a cupcake invasion in 3. Just moderators, thank you so much for everything you do for me today and all days. Moderators are amazing here. They keep it classy. And all of you keep it classy as well. Peace, my friends. Stay cool, kind, and classy. I'll probably see you tomorrow on something else. So smash the subscriber button. It's free. Hit the bell. And let's go over to Nurse Kim and do a cupcake invasion in 3, 2, 1. Buckle up, buttercups.